Mr. Burnett, you're here on the civil pretrials today, right?
Yes, good morning, Your Honor. We're here for LAFQ. It's just a couple debtors exam hearings, and one was a control date for documents.
All right. So are you here on? So I've got you here on the two LAFQ case. Are you here on the automakers case too?
I do not do.
All right. Well, let's call your cases first. I'm not sure what that file. And it's not on the docket, but it was in. So let's call on the record. Docket 17-00790GC. That's LAFQ versus McMillan, Ambrose McMillan. Will the parties please introduce themselves for the record?
Yes, good morning, Your Honor. My name is Joe Burnett. I'm filling in for Tim Smith on behalf of LAFQ.
All right, and this is, thank you, Mr. Burnett. This is the time set for a discovery hearing on the matter. And I don't see, now there's somebody in the courtroom. Now, are you Ambrose McMillan or Dominic Trevino? Neither? All right. This is set for 8:30. It's now 8:47. Discovery hearing. I have that Ms. McDillon was served on this. We served her. I mean, she received the subpoena from the court. And then I have that she was served. Mr. Burnett, how would you like to proceed?
We would like to request of the court a bench warrant for Ms. McMillan. I understand if you would prefer a motion to show cause, but we would just like to request a bench warrant.
Well, there's a previous defendant failed to appear. That was on May 4th, and a bench warrant was issued. On this matter. So there's a previous fail to appear. So I'll FTA the defendant at 8:48 today. Bench warrant issued.
Could we request a cash bond, Your Honor?
Yeah, there was a 250 cash bond set last time. So I'll do a $250 cash bond.
Okay, thank you, Your Honor.
So that's on the record 1700790. Then we have docket 1704685. This, so will the parties please introduce themselves for the record?
Yes, thank you, Your Honor. This is my name is Joe Burnett. I'm an attorney with Smith and Johnson, filling in for Tim Smith on behalf of LAFQ.
And this was originally set, and it looks like the parties met in a breakout room. We put a control date for June 6th. I have indication that plaintiff to send a letter. An additional pretrial date was set because it looks like the parties were working on it. And then once again, we have a fail to appear. And this is the first fail to appear on today's date, July 11th. I don't see Mr. Trevino in the courtroom. There's nobody in the Zoom courtroom. Mr. Burnett, how would you like to proceed?
Thank you, Your Honor. Mr. Trevino has been paying through his wage assignment. So this was, as you said, just a date for documents. We did send a letter, as discussed in the last hearing, but I believe, I don't know if a bench warrant is necessarily appropriate. We could just do a motion to show cause since he is making his payments. So
All
I
right,
guess
I'm gonna set for motion to show cause for FTA. Defendant is making payments. You need a date for that. Let me make sure I know who sets that date. Jay would set it. Yeah. All right, the civil division will set that date. I've set promotion for show cause because defendant is currently making payments. And then you should receive that date from the civil division of 54A.
Okay. Is it all right if we serve the defendant by mail for motion to show cause?
Yeah, if he's still in the apartment, let's serve him by mail. He'll also get a notice from us too, from the civil division, and then we'll go from there.
Okay, thank you, Your Honor.
It sounds like you're still in contact with him.
Yes, from what I understand, yes.
All right. All right, that's all on the record in 1704685. Anything else today, Mr. Burnett?
I do have one file. It's Lafkew versus Winton Harris. Does that sound familiar at all?
Yes, that's our very first file. Winton Harris?
Correct.
I have that as Lansing Automakers. Okay. So you have the very first file. All right. So I have that as filed 1203905. Lansing Automaker, yeah, Lafkew versus Winton Harris. Will the parties please introduce themselves for the record?
Yes, thank you, Your Honor. My name is Joe Burnett. I'm filling in for Tim Smith on behalf of Lafkew.
And this is the time set for a discovery proceeding. This was set for 8:30. It's now 8:53. I don't see Mr. Harris in the courtroom or the Zoom courtroom. Mr. Burnett, how would you like to proceed today? There's an indication that he was served by first-class mail.
That's correct, Your Honor. The proof of service that I have says it was first-class mail, and apparently they put the notice on his door as well.
Mr. Burnett, how would you like to proceed today?
We would like to request a bench warrant, Your Honor, with the cash bond. Yes.
All right. It's like you previously posted a cash bond of $250. At least there's paperwork to indicate that. Cash bond receipt.
Okay.
All right. I have defendant failed to appear. Bench warrant authorized. That'll be a $250 cash bond. Anything else for the record on 12-03905?
I believe not, Your Honor. Sorry about the confusion there. I guess sometimes I forget what LAFQ actually stands for, the acronym.
No, it's completely my fault. I read the docket and then one was spelled out and the other was an acronym. So we're all set.
Okay. Well, thank you, Your Honor. I appreciate it.
Thank you too. Have a nice day.
You too.
And Ms. Sutter, you're here, and Ms. Robinson's here on the 9 o'clocks. Which ones are yours, Ms. Sutter? Ma'am, on the device CP3705AS, will you please introduce yourself?
Marquis Farrar?
Yeah, Marky, I've got you.
Okay, sorry.
You know, and Mr. Simmons, I have you. Mr. Perez, I have you. Mr. Spraker, ma'am, what's your name on the cell phone device?
Tara Simpson.
Terrence Simpson. All right, you're here for your 9 o'clock. Thank you, Ms. Simpson.
You're welcome.
And Mr. Abbott, you're here for the sentencing?
Yes,
Mr.
Your Honor.
Olson? All right, just making sure I know who the players are right now. Thank you.
Right. Thank you.
So we're on the record in docket 22-01185 and same number 22-01186. We'll start with 85. That's people of the state of Michigan versus Markey and Farrar. Will the parties please introduce themselves for the record?
Thank you, Your Honor. Good morning, Erin Housefield on behalf of the people.
And ma'am, you are Markey Farrar,
Correct.
and you can hear me all right, Ms. Farrar?
Yep.
All right. Ms. Housefield, this is the date set for a pretrial on 2 matters. How are we proceeding today?
Thank you, Your Honor. This was last set in July. If the court may recall, the defendant showed up on Zoom, but then went out perhaps with some technical difficulties. So I've never had a chance to speak with Ms. Farrar. I can either go into a breakout room if you'd like and conduct a pretrial and then come back.
Yeah, whichever. Ms. Farrar, you have 2 files here with concerning these matters. Would you like to meet with the assistant prosecutor in a breakout room to discuss these matters?
Sure.
All right, so let's do that. I'll wait for you to jump on board here and. What room are you gonna put in? 2. Room 2. So you'll be placed in room 2 with the assistant prosecutor, okay? Thank you.
Thank you.
All right, we're back on the record in docket 22-01185. Ms. Houseville, you've had the opportunity to speak with Ms. Farr on these files.
I have, Your Honor. Thank you.
And how are we proceeding today?
Thank you, Your Honor. Ms. Farr has 2 tickets, 1 in each file for failing to have her dog or dogs, in this case, licensed and vaccinated according to the ordinance. She did show me that she has complied and has both Zeus and Loki properly vaccinated and licensed and vaccinated. My apologies, Your Honor. And so at this time, the people are moving to dismiss the tickets in both 22-01185 SM and 22-01186 SM.
For compliance. And Ms. Farrar, that's your understanding of what we're doing today?
Yep.
All right, so in regards to docket 22-01185, the people move to dismiss for compliance. Ms. Farrar has complied with the statute concerning her dogs, and as to docket 22-01186, people dismiss per compliance with statute. I'll put dismiss without prejudice just for. So Ms. Farrar, both files are dismissed for the people of the state of Michigan. Key here is to keep those dogs licensed, right?
Yep.
All right. Anything else for the record in 22-01185 and I will, and also 22-01186 as part of both of these files, Ms. Houseville.
No, Your Honor, thank you.
Ms. Farrar, anything else?
No, thank you.
All right. Thank you. Have a nice day, ma'am.
You too. Thank you so much.
Let's go on the record in that. So on the record in docket 21-02263, that's people of the state of Michigan versus Paul Perez Argumedo. Mr. Perez, are you there? Mr. Perez? Can you hear me, Mr. Perez? I saw you just unmuted yourself.
Yes, I can hear you.
All right. Am I able to see you, sir?
Yes, one moment. Yeah, I gotta talk to the judge right now. Okay, thank you, bye.
You're actually in the Zoom courtroom right now.
Yeah, I was just talking to my lawyer because we had a miscommunication problem.
Oh, okay. So you are represented by counsel today?
Yes.
All right. So I'm going to put it on the record. Let's go on the record in docket 21-02263. Will the parties please introduce themselves for the record?
Thank you, Your Honor. Aaron Houseville on behalf of the people.
And sir, you are Raul Perez Argumedo?
Yes, correct.
All right. And sir, you've just indicated that you are represented by counsel today?
Yes.
And who is that, sir?
Levi and Burnett.
And is Mr. Burnett going to be able to join us today?
Yes, the
Oh,
issue we had was the issue we had was he thought today's meeting was in person, so he went to in person, but it's over Zoom. So right now he's trying to join right now.
All right. And you are Mr. Burnett?
Yes, that's correct. Good morning, Your Honor. Attorney
All right.
Levine here for Raoul.
All right. And so we have all the parties here. And have you had the opportunity to speak with Ms. Housefield, the assistant prosecutor on the case?
No, I have not, Your Honor. I was just retained Sunday evening with a payment that literally just went through this morning. So I contacted the court staff for an appearance and a substitution of attorney to the extent that a PD's office is assigned, but I have an appearance that's being emailed here in minutes.
All right. Ms. Housefield, how do you want to proceed today?
Your Honor, I can go into a breakout room and speak with counsel.
Mr. Levine, would you like to speak with Miss Housefield in a breakout room? Just to get the ball started today?
Indeed, I would. Thank you, Your Honor. Absolutely. Thank you.
All right. All right. You will get a prompt. What room are they going to? All right. So you'll be going to room 2, and Miss Housefield will return to breakout room 2. Mr. Perez, your counsel is going to meet with the assistant prosecutor, so you can stand by. All right.
Okay.
All right. Thank you.
Thank you.
Thank you, Your Honor.
and docket 21 at 02263. People of the state of Michigan versus Raul Perez Argumendo. And Ms. Housfield, you've had the opportunity to speak with Mr. Levine.
I have, Your Honor. Yes, thank you.
And how are we proceeding today?
Thank you, Your Honor. Given that he was just retained, there's been no discovery at this point. So the people and Mr. Levine would be asking for an adjournment. Additionally, Your Honor, the offer on this matter is to have the defendant screened for participation in the 54B District Court Sobriety Court. And given the nature of the screening process with an adjournment, the people would ask, and I think there would be no objection from defense counsel, that it be adjourned for a longer period than just a week or two so that discovery can be received and we can start that screening process.
That's the 54B sobriety court.
That is correct, Your Honor.
Mr. Levine, is that your understanding of what we're doing today?
That is, Your Honor. It's an accurate statement.
All right, so we'd be looking for an adjournment date outside of what, August 15th at 9?
That would be fine, Your Honor. Thank you.
August
It'll be
15th
fine. Thank you.
at 9 a.m. So, Mr. Perez Argumento, you've heard the lawyer speak. You're to be back in this court depending on the screening procedure. But the next date in court is set for August 15th at 9 a.m. Okay.
Okay, Your Honor.
And if you have any questions, please keep in contact with your attorney, Mr. Levine. Do you have anything else for the record, Ms. Housfield in 2102263?
No, Your Honor. Thank you.
Mr. Levine, anything?
Not from here, Your Honor. Thank you.
All right. Thank you for your appearance. Everybody have a nice day.
Thank you, Your Honor. You as well. Thank you.
Thank you.
The sentencing first. So we're on the record in 22-01095. People of the state of Michigan versus James Anthony Little. Will the parties please introduce themselves for the record?
Thank you, Your Honor. Erin Housfield on behalf of the people.
Erin Robinson, Assistant Public Defender, on behalf of Mr. Little.
And sir, on the Polycom, you are James Little?
Yes, yes, I am.
All right. And you can hear me all right, Mr. Little?
Yes,
All right. This is the time set for a sentence on this matter. There has been a report done. Miss Robinson, any additions, deletions, or corrections to the report?
So I don't believe that I received a copy of the report. Would it be possible to get that? I wasn't sure if one was done or not.
Yeah, there's a report. It's a one-page report. And I can let you read ours. There's not much to it.
Sure,
And then we
absolutely.
can make sure and you get a copy of it. Have you seen that?
No,
All right.
she doesn't mind. I'll read over her.
Yeah, you can both read it. There's not a lot to it. All right, thank you. So, we've, the council's been given the opportunity to look at the report. For the record. It's 5 paragraphs long on one page. Any additions, deletions, or corrections to what was written?
No, Your Honor.
All right. Anything in regards to allocution from Ms. Robinson?
Well, yes, Your Honor. At first, I think we need to address the PA 53, the contempt case as well that's going along with that. So I understand that there was a pretrial release violation that was filed for this case. However, it looks like those are going to be stemming, or some new charges will be coming from that. And so I don't really think it's appropriate to handle that while those have not yet been filed. So we can either continue that, or if the court would be willing to dismiss it, it looks like he's going to be, like I said, he's had 63, I think, days in custody so far since the time that PSI was written. As far as the sentencing, he also is being held on a case out in 55th. And I'm not sure it's gonna be in the best, I guess, way of judicial resources to be putting this off to doing this when it's going to be coming down the pipe anyways. It will likely be a case that's filed with the city attorney with those additional charges. So I would ask that, that would be dismissed at this time, and then we can just go forward with the regular sentencing.
Ms. Housefield, and just correct me if I'm wrong, it's my understanding that there is a PA 53 violation. That sentencing is separate from this sentencing because it can be done consecutively. My also understanding is that if charges are to come out of the no contact order, then we have to address whether we want to view those charges in light of the PA 53 violation and those allegations, or whether we want to address those facts in a new charge. I mean, quite frankly, it's been a long time since I've read the double jeopardy aspects of it, but that's what I would fear.
Thank you. Yes, Your Honor. And it's interesting to note, I reviewed the police report that was filed as part of the PA 53 proceeding. It was not, in fact, a violation of the no contact with any of the victims that are listed in the original case, the 3 assault and batteries and the retail fraud. What this is, Your Honor, is the allegations in the police report are that he was essentially trespassing at a business, and when police made contact, he was potentially, allegedly under the influence of alcohol. So violating the no new criminal charges and no alcohol provisions of the PA 53. That police report was sent to the city attorney's office for review and issuance of charges on the trespass and or potential open intox or any type of intoxicated. And so there's nothing in the new police report and the potential allegations that are linked to any of the victims or the location, the Quality Dairy, which is the location of the original incident for which we are here in sentencing. Okay. So I would defer to the court. It is certainly Your Honor's order, but if the court felt it appropriate to dismiss the PA 53 sentence, given the number of days that he's currently been in custody and the extent to which the court can sentence, and then if the city attorney's office, it determines charges are appropriate, handle those in a separate proceeding.
In a separate position, right? And then we take care of any going over the same charging aspects.
Yeah.
So all right, so let's go on the record. So let's go on the record in the PA 53 contempt order, which is the same record 2201-095, and so that seems to be a more efficient process. Parties introduce themselves for the record again, and then we'll go from there.
Thank you, Your Honor. Erin Housefield on behalf of the people.
Erin Robinson, Assistant Public Defender on behalf of Mr. Little.
And sir, you are James Little, sir?
Yes, sir.
All right, and sir, just to bring you up, we have two files we're looking at today. One is a violation of the PA 53. The other one is a sentencing. After speaking with both counsel, I'm going to move to dismiss the PA 53, or I'm going to dismiss the PA 53. And it appears that the city attorney is going forward with allegations on that which are somewhat the same and somewhat different than these. Is that fair, Ms. Housefield?
What I can say, Your Honor, is that the police report has been filed with the city attorney. I don't know if they intend to issue any charges or dismiss, but rather that it's not with my office.
All right. So I've dismissed this PA 53 that comes out of this court, and we will go back on the record in the sentencing of Mr. Little after discussing the PA 53 violation. Ms. Housefield, Ms. Robinson, anything as to allocution on this file now that we've taken care of the PA 53 file?
Yes, Your Honor. I spoke with Mr. Little and he does apologize for his actions. I know that there was an original Killebrew agreement to 30 days in custody. However, with the bond violation, I know that that's no longer in effect. However, he has been in custody for the past 63 days. He is also serving some time on another case out in 55th and will remain in custody on that for a little while as well. I would ask the court to sentence him to time served on this case since it is well over the Killebrew of the 30 days. Further, Mr. Little has stated that he is open to getting help with community mental health and has reached out to the CAPS program while in custody. And I instructed him on how to get in contact with them, and he said he would be open to that as well. So I would just ask Your Honor to sentence him to be time served. Thank you.
Anything, Ms. Housefield, on the sentencing of Mr. Little?
No, Your Honor, thank you.
Okay. So I have as a sentence of this court on count 1, the assault and battery, and count 2, the assault and battery. And you are represented by counsel, sir. I am going to, so yes, 63 days served is my understanding. Is that right?
At the time that the PSI was written, that was my understanding, yes.
Right. So I'm going to give it full credit for time served, 63 days previously served on the matter. I'm waiving all fines and costs. There is a crime victim's right that I can't waive of $75. That's the sense of the court.
Thank you, Your Honor.
Thank you. I'll just stick there. So, Mr. Little, you're all set today, okay?
Okay, all right, thank you.
Ms. Sutter, are you ready to go on Victor C. Simmons or Simons?
Yes, Your Honor.
All right. We're on the record in dockets 22-00604, people of the state of Michigan versus Victor C. Simons. Will the parties please introduce themselves for the record?
Thank you, Your Honor. Erin Housefield on behalf of the people.
Good morning, Your Honor. Assistant Public Defender Lauren Sutter on behalf of Mr. Simons, who is present via Zoom.
And sir, you are Victor Simons?
Yes, I am, Your Honor.
Okay, and you can hear me all right, Mr. Simons?
I can.
All right, Ms. Housefield, how are we proceeding today?
No, thank you, Your Honor. There is no offer in this matter at this time, so I defer to Ms. Sutter. I imagine that she'll want to have it set for final pretrial, jury trial.
Ms. Sutter?
That is correct, Your Honor. I would ask for final pretrial and a trial. I would, however, ask the court to set the trial a little bit further out from the final pretrial than normal. Mr. Simons just informed me in a breakout room that he has actually retained Mr. Samoris. I have not heard anything from Mr. Samoris myself, but I'm going to be giving him a call. So I do believe a substitution of counsel might be incoming.
Yeah, and I just saw him on Zoom. I think he's just been let in the room I can confirm that with Mr. Samoris, and then we can set it for final pretrial and jury trial date.
Thank you, Your Honor.
He's connecting on audio right now as we speak, which may be a little bit of time or a lot of time depending.
Understood.
We're now done.
Mr. Samoris, how are you?
I'm doing well. Thank you, Your Honor. How are you?
And are you here on the Simons case?
Yes.
All right. So I've already called that to the record. There's an indication from the public defender that Mr. Simons has retained you.
That is correct, Your Honor. And I think my appearance and Mr. Simons, and by the way, just to clarify with my client, I think it's Simmons. He just happens to be with one M. I don't know if that's
it is Simons.
It is Simons, and then I stand corrected. So, so basically, Your Honor, that's where we're at. I filed my appearance. I think they just crossed over with my client's notification that the court had appointed him an attorney.
All right. My understanding from Ms. Housefield is that she did receive an appearance for the record.
That is correct, Your Honor.
All right. So there's no offer on the table at this point in time. So we'll set it for a final pretrial and jury trial outside the date since you were just retained. And so to give you more time to look for discovery issues and to contact your client.
Thank you very much. That'll work out.
So what's a date? A little further date. Okay.
Final pretrial August 1st and jury trial August 22nd.
Okay, so we'll have a final pretrial date of August 1st.
Okay.
And then jury trial would be set for August 22nd.
Okay.
At 8. And those set out a little bit to give since you were just retained.
Great. Thank you, Your Honor.
All right. So so may I just indicate, confirm both those dates with your client, Mr. Samoris?
Yes, Your Honor.
All right, Mr. Simons, go ahead.
Mr. Simons, were you able to hear and understand everything that Judge Flores just mentioned?
Yep.
So our next court dates are August 1st. And if we don't resolve the case, then the jury trial would be August 22nd.
Okay.
Okay. And in the
Thank you,
process, thank you.
Go ahead. Go ahead.
I was going to say, in the process, if we resolve the case, if I can get a different date, I will promptly call the court and keep everyone advised.
Okay.
Thank you, Mr. Samoris. Is there, so if you have any questions, keep in contact with your attorney, Mr. Samoris. Anything else for the record on 2200604, Ms. Housefield?
No, Your Honor, thank you.
Anything, Mr. Samoris?
No, Your Honor. Thank you.
Your Honor,
All right,
I apologize. Just quickly, given that I have filed an appearance in this file as well, does the court require a substitution of counsel, or is Mr. Samoris's filing of an appearance enough?
We
thought-
should have a substitution of counsel for the file.
I thought my appearance made it first, though. So, because I was told that there wasn't an appearance in the file, and nor have I gotten. So, but either way, it's fine. All right. Thank you.
All right, thank you. We'll need a substitution because I'm not sure which one came first.
Very well. Thanks.
All right. So that's all for the record, 2200604.
Thank you.
Thank you, everybody, for your appearances.
Thank you.
How about Miss Simpson? And then we. Docket 21-01360. That's people of the state of Michigan versus Tara Cerise Simpson. Will the parties please introduce themselves for the record?
Assistant Public Defender Lauren Sutter on behalf of Ms. Simpson, who is present via Zoom.
And ma'am, you are Tara Simpson?
Sir,
All right. And this is and you can hear me all right, Ms. Simpson?
yes, can.
All right. This is the time set for I have it as a deferred sentencing on a dog bite. Ms. Sutter, how are we proceeding today?
Thank you, Your Honor. I've spoken several times with Ms. Simpson over the past weekend and late last week. She's been making efforts to pay the remaining balance on this underlying charge. However, she did inform me that she was having trouble coming up with a full payment on Friday, and she also spoke with me again over the weekend concerning this. At this time, I do understand that there is still a remaining balance on Ms. Simpson's account. She was trying to pay it off this morning. I think the online service bill took her a bit by surprise, as well as some family obligations that she's trying to struggle with. If the court is willing, I would respectfully request that Ms. Simpson still be given the benefit of the deferred sentence and have the remaining balance continue to collections for her to make in the next week, is what I believe she explained her plan to me to be. Rather than having a criminal conviction on Ms. Simpson's record when she has been making efforts to continue paying faithfully on this underlying fee. Thank you, Your Honor.
Thank you, counsel. Let me check our computer just to see that it lines up. All right. Ms. Sutter, so this is a different file as I look at it. That seems to be this started out with fines and costs on what is essentially a dog bite case without restitution of over $500. Is that my reading of this, Ms. Sutter?
That's correct, Your Honor. I think she has a remaining balance of $257.
Right, I have $257 remaining balance. So the entire case is bent on the completion of the $275 in deferred sentence on this dog bite case. That's my understanding, right?
Yes, Your Honor.
Right. So I'm going to accept the deferred sentence as indicated. So I'm going to dismiss the file, and then I am going, since in my opinion this is such the costs on this are high. I'm not going to refer it to collections. I'm just going to dismiss the file outright with the deferred sentence. So I'm going to, as a part of the deferred sentencing, I'm going to dismiss the case. And I'm going to dismiss the remaining balance.
Thank you, Your Honor.
Thank you so much.
And Ms. Simpson, this has probably been an ordeal, so you probably know that you never want to have your dog unlicensed or biting anybody again, right?
Oh, yes, I do.
All right. We'll make this a learning experience for all of us, all right?
Yes, thank you so much. I appreciate that.
All right. Anything else for the record? 21-01360, Ms. Sutter?
I have nothing further, Your Honor. Thank you very much.
All right. Ms. Simpson, have a nice day, all right?
You too. Bye, Lauren.
Bye, Ms. Simpson.
All right, we're on the record in docket 21-02553. That's people of the state of Michigan versus Sarah Harrelson. Will the parties please introduce themselves for the record? Mr. Abbott, that's your case.
Good morning, Your Honor. John Abbott representing Ms. Harrelson. She appears by video from the jail.
And ma'am, you are Sarah Harrelson?
Yes, I am.
All right. And you can hear me all right, Ms. Harrelson?
Yes, I can.
All right, thank you. Mr. Abbott, you've had the opportunity to see the pre-sentence report. I am also in possession of your memorandum that you filed with the court on this case. Any, besides your memorandum, which you've indicated, are there any, and I'll just make it a part of the pre-sentence report. Are there any additions, deletions, or corrections from the actual report other than the memorandum which you filed?
No, Your Honor, I met with Ms. Harrelson Friday and we didn't identify any additions, deletions, or corrections.
All right. And so anything by way of allocution in the case, sir?
Thank you, Your Honor. I'll be brief since you've already read what most of my ideas are. The recommendation is for 90 days and then suspend. She'd spend more time in jail, 30 days more, or suspend 30 days. I'd request that the court, you know, if she actually gets into a rehab program, if she completes it, that you would suspend the rest of the sentence. Other than that, because I don't think the punitive part of it is really as important. I mean, she's injuring mostly herself due to these illegal acts. But other than that, so nothing, Your Honor. Thank you.
So your allocution today is to follow the recommendation, but suspend the remaining jail time on the completion of the residential treatment, as opposed to having, it looks like 30 days would be left.
You said it much clearer than I did. Yes, thank you.
I don't know about that. Ms. Harrelson, I understand you, Mr. Abbott's argument in the case. Is there anything you'd like to say on your behalf before the court passes sentence?
That I am still working on myself and I am currently homeless right now, but I do plan on checking into either CMH or St. Lawrence after leaving incarceration.
All right. Well, I think that's probably the most important, the important aspect here. is that you understand the necessity and the need for that. And I think that's important in this case, most importantly for yourself. Is that correct, Ms. Harrelson? That's the most important part. I'm going to accept the recommendation of the JOS, except with one small change, and that is the one suggested by Mr. Abbott, which I agree with. So I'm going to suspend the 90 days in jail beginning July 11th, 2002. Credit is given for 14 days previously served. I'm going to suspend any remaining jail time upon the completion of a successful residential treatment, which it appears that you're applying for. Is that correct?
Yes, Your Honor. And I just recall that there was one change. Since the report was written in December 6th and there was 14 days then, she's been in jail now waiting sentencing for 13 days. So I think credit should be 27 days.
Okay, so credit for 27 days.
Yep.
Thank you. I'm sentencing on the count one, the breaking and entering illegal entry. I'm waiving all fines and costs. There is a crime victims fee that's mandatory $75. There's a state minimum cost of $50. There's restitution in this matter to Ahmad El Bast for $450. That's part of the court's order. Anything else for the record, Mr. Abbott?
No, thank you, Your Honor.
Do you understand that the most important thing that comes out today, Ms. Harrelson, is the continued treatment and the successful treatment? Do you understand that, ma'am?
Yes, I do.
All right. So that's all on the record in dockets. I want to make sure I get the docket number right. 21-02553.
Thank you, Your Honor.
Thank you. You're all set, Ms. Harrelson. Thank you for your appearance.
All right, yeah, no, thank you.
Here we go. So let's do that again because I was on mute. So on the record, docket 22-00596. That's people of the state of Michigan versus Kevin T. Spraker. Will the parties please introduce themselves for the record?
Thank you, Your Honor. Erin Housefield on behalf of the people.
And Ms. Sutter, you're here on Mr. Spraker. We lost one.
If you start in the hallway, Your Honor. I'll check.
Okay. Let's see the breakout room, but she might be in there. Oh, she just said, I apologize. I stepped out of the room. Am I needed right now? There she is.
Hello.
Hello, Ms. Sutter. Yeah, we went right to the file. So this is 22-00596. people of the state of Michigan versus Kevin T. Spraker, and you're here on behalf of Mr. Spraker, correct?
That is correct, Your Honor.
All right, thank you. And you are Kevin Spraker, sir?
Yes, Your Honor.
All right, and you can hear me all right, Mr. Spraker?
Yes, sir.
All right, Ms. Houseville, this is the time set for a pretrial on this matter. How are we proceeding?
Thank you, Your Honor. At this time, there's no offer on the file. I defer to Ms. Sutter.
Thank you, Your Honor. Thank you, Your Honor. Given that there is no offer at this time, Mr. Spraker and I have discussed it, and we would be asking the court to set us for a final pretrial and jury trial.
All right, set for final pretrial and jury trial. And I will give you those dates in a second.
Thank you.
So August 1st at 9 a.m. for the pretrial. 8:30.
8:30, okay.
And then jury trial is set for August 8th at 8 p.m. 8
And
a.m.
I apologize, Your
8 a.m.
Honor. I believe I already have a commitment on the 8th. Is there another date that's available?
Yes. Yeah, for the jury. August 22nd at 8 o'clock.
Unfortunately, Your Honor, I also have a commitment on that day. I apologize.
How about this? How about let's keep the 22nd date with the understanding that it may or may not be workable. And let's see what happens at the final pretrial.
Thank you, Your Honor.
Does that work? Yeah, let's do that. So Ms. Sutter, I'll briefly inquire of your client just as to the dates. Right now we're set for final pretrial on August 8th. What day is it? August 1st, right? Wanna make sure.
Final pretrial is August 1st.
Okay. So the final pretrial set at August 1st at 8:30 in this court. So right back in the Zoom courtroom. And then we have set your jury trial for August 22nd at 8 a.m. Depending on what happens on August 1st. So stay in contact with your public defender, Ms. Sutter, and we'll see you again on August 1st. Okay, Mr. Spraker?
Yes, Your Honor.
All right. Anything else for the record, Ms. Housefield?
No, Your Honor, thank you.
Anything, Ms. Sutter?
And nothing further, Your Honor. Thank you.
All right, that's all on the record in 22-00596.
Thank you.
Thank you.
Sir, okay.
Hello. Good morning.
Good morning.
Good morning. Sir, on the Samsung SMA136U, will you identify yourself for the record?
Charlita Beard.
And Miss Beard?
She's the victim, Your Honor, on Andrew Stewart.
All right, so she's here on Stewart. That's at 10 o'clock. On the Samsung A136U, sir, you're in a plaid shirt.
Yes, sir. I am Jeffrey Medina.
All right, you're here up for your 10 o'clock, sir.
Yes, sir.
And then, ma'am, on the Samsung SMS901U, if you
Yes.
could identify yourself.
Oh, sorry.
Yeah. I have you, Ms. Stewart. Thank you. On the Samsung, can you identify yourself?
Kathy Hunt.
All right, you're here for the 10 o'clock.
Yes.
All right, and then, sir, on the Samsung A136U in the blue T-shirt.
Oh,
Yeah, this is
Charlita
Joe.
Beard. I don't know. I'm sorry.
Yeah, I've got you, ma'am. Sir,
Oh, okay,
what's your
thank
name?
Talking to me?
Yes, I'm talking to you.
Oh, my name is Butler.
Maurice Butler here for your 9:30. And then, sir, not the other individual on the Samsung, I mean, in the blue, not Martise Butler, but the other individual. What's your name, so I can identify you for the record?
Who, me?
Yes, you, sir.
Joseph Havens. Joseph Havens.
All right, you're here for your 9:30.
I have a 9:30. I waited exactly 45 minutes. It says down here
All right,
that Zoom for-
where's Mr. Butler? Everybody's waiting. We're just getting in line. We got a lot of files. Okay.
Yeah, I understand.
Mr. Havens and Mr. Butler, your cases are coming up next. So we're going to go on the record in Joshua Joseph, who is not in the courtroom and not in the Zoom courtroom. So I'll call the file of docket 2201-463. Will the parties please introduce themselves for the record?
Thank you, Your Honor. Erin Housefield on behalf of the people.
Erin Robinson, Assistant Public Defender, on behalf of Mr. Joseph.
And this is the time set for a pretrial in the matter on Mr. Joseph. It's 9 o'clock. It was set for 9 o'clock. It is now 10:16. Ms. Housefield, how are we proceeding?
Thank you, Your Honor. At this time, the people would request a bench warrant bond forfeiture.
Ms. Robinson?
I believe this is his first failure to appear on the file, so I'd ask for a 48-hour hold.
Ms. Housefield, any objection to 48-hour hold? Looks like it looks like an RNC under.
As long as it's the first failure to appear, Your Honor, which my notes indicate it is,
All
but I
right.
don't have any information prior to today's trial.
Okay, that's my information also. I don't have a previous fail to appear. So bench warrant forfeiture is issued and a 48-hour hold is set. Anything else for the record, Ms. Housefield?
Nothing for the people, thank you.
Ms. Robinson?
No, Your Honor.
That's all for the record in docket 2201-463. So on the Polycom in the Ingham County Jail, can you identify yourself, sir?
Dylan Carr.
So we're on the record in docket 22-01684, people of the state of Michigan versus Martise A. Butler. Will the parties please introduce themselves for the record?
Your Honor, Aaron Housefield on behalf of the people.
Good morning, Your Honor. Assistant Public Defender Lauren Sutter on behalf of Martise Butler.
And sir, you are Martise A. Butler?
Yes, sir.
Okay, and you can hear me all right, Mr. Butler? All right, this is the time set. This is the time set for a pretrial in this matter. Ms. Housefield, how are we proceeding?
Thank you, Your Honor. There are no offers at this time. I will defer to Ms. Sutter.
Thank you, Your Honor. Thus far, I've been unable to speak with Mr. Butler. If I could have a very brief breakout room with him, I believe we'll likely be setting for a final pretrial.
Okay, so I would have Ms. Sutter going back to the room she was in, which is room 2, I thought.
Room 1, I
Room
think,
1.
Your Honor.
All right, and then Mr. Butler, I'm going to place you with your public defender in room 1.
All right.
Thank you. Here, or it's right, you can come up, ma'am. So we're on the record in docket 22-00255. That's people of the state of Michigan versus April O. Lorick. Will the parties please introduce themselves for the record?
Thank you, Your Honor. Aaron Housefield on behalf of the people.
Good morning, Your Honor. Matt Nagel on behalf of Ms. Lorick, both of us present.
And you are April Lorick, ma'am?
Yes, sir.
All right. Ms. Housefield, this is time set for a pretrial in the matter. How are we proceeding?
Thank you, Your Honor. By my notes, this is the time set for a final pre-trial, Your Honor. At this time, the people have not had sufficient contact with the victim and are unable to proceed. The people will make a motion to dismiss without prejudice. I've discussed with Mr. Nagel the potential for refiling should I have appropriate contact with the victim.
And that's your understanding, Mr. Nagel?
There's an accurate statement. Yes, Your Honor.
All right. So may I explain that process to your client, sir?
Of course, Your Honor.
Ms. Lorick, today the case is being dismissed, okay, at the final pretrial stage. It's being dismissed without prejudice, which means that the people could reissue if necessary. But for today's purposes, the case is dismissed. Do you understand that, ma'am?
Yes, sir.
All right. Anything else for the record in docket 22-00255, Ms. Housefield?
Only, Your Honor, that I will present Anali in just a moment.
Correct. Yeah.
Thank you.
And anything else, Mr. Nagel? The people are going to sign the Nolly right now. We give it to them, and then I'll sign it after that.
Thank you, Your Honor. Nothing further.
All right. Thank you.
And Your Honor, when I was speaking with Mr. Butler in the breakout room, he went robotic and then froze, and after about 30 seconds disappeared. So I think he may have lost internet connection.
All right. Well, we'll wait on Mr. Butler then. Okay. All right, so while we're waiting for Mr. Butler, who's got some technology issues. Say that 3 times. Let's go with Mr. Haven. So that's docket 22-01290, People of the State of Michigan versus Joseph Allen Havens. Will the parties please introduce themselves for the record?
Thank you, Your Honor. Aaron Housefield on behalf of the people.
Good morning, Your Honor. Assistant Public Defender Lauren Sutter on behalf of Mr. Havens, who is present via Zoom.
And sir, you are Joseph Havens?
I beg your pardon?
You are Joseph Havens, sir?
Yes, that's correct. To let you know, inform you, and well aware of, I have a hearing impairment, so I wear hearing aids, so it's a little hard to hear at times.
I understand. So yeah, that suffices to answer my next question. As long as we can communicate, this will work, all right? You let me know if you can't hear me, sir, all right?
Yes, sir.
All right. This is the time set for a pretrial in the matter. Ms. Housefield, how are we proceeding?
Thank you, Your Honor. At this time, the people will be filing a nollie for a motion with a dismissal without prejudice.
There's no objection from defense, Your Honor.
And this is the final pretrial, so.
That is correct, Your Honor.
All right. Ms. Sutter, may I explain to Mr. Havens what that means today?
You may, Your Honor. Thank you.
Mr. Havens, the people are moving to dismiss this case without prejudice, which means that today the case is dismissed. They may be able to refile later if they choose, but for our purpose today, the case is dismissed. Ms. Housefield will be providing the court a nollie process that I'll sign, and the case for today is dismissed. Do you understand that, sir?
Very much so, yes, sir.
All right. So anything else other than the signing of the nollie process, Ms. Housefield?
No, Your Honor, thank you.
Anything else, Ms. Sutter?
Nothing, Your Honor. Thank you.
All right, Mr. Havens, you're all set. I'll sign the nollie process, and that's all on the record in 22-01290.
Yes, sir.
Thank you, Your Honor. And Mr. Havens, you're all set to log off from Zoom.
Yes, ma'am. Thank you.
So we're on the record in docket 20-03455, People of the State of Michigan versus Robert Sparks. This is set today for a pretrial and a motion if necessary. We'll start with the pretrial. Looks like it looks like an adjournment from the prior pretrial on June 13th. Will the parties please introduce themselves for the record?
Thank you, Your Honor. Aaron Housefield on behalf of the people.
Erin Robinson, Assistant Public Defender on behalf of Mr. Sparks.
And this is the time set for a pretrial in the matter. Ms. Housefield, how are we proceeding?
Thank you, Your Honor. Understanding that there's also a motion set, I believe if I may address the motion first.
Okay.
Thank you, Your Honor. Defense counsel filed a motion which I believe is to be dispositive of the case. The people filed a response. If Your Honor may recall, we were before the court on June 13th. At that time, the people did not have the appropriate police officer witness to present the evidence necessary for the court to rule on that motion. The people requested an adjournment of the motion. The court granted that. We are here for that today. The people have subpoenaed the officer. I can't speak as to why the officer is not here, but at this time, Your Honor, the people cannot proceed on the motion. I believe it would be appropriate for Ms. Robinson to make a request for a dismissal. If people believe that that's the appropriate outcome, and at this time, Your Honor, will file a nollie for a dismissal without prejudice.
Thank you. Ms. Robinson?
We would make such motion, Your Honor.
Okay, so D moves to dismiss. Based on the motion. To suppress. Plaintiff unable to proceed or prosecutors unable to proceed. So the file is dismissed pursuant to the motion, defendant's motion to dismiss and the prosecutor's inability to proceed with the motion. Anything else for the record in docket 20-03455 from the people?
No, Your Honor, thank you.
From the defense.
No, Your Honor.
So that would alleviate any further proceedings on this file 20-03455. Let's go on the record in docket 22-00831. People of the state of Michigan versus Ronnie Williams. He's not on. He's not on. Is he here today? Okay. So we're just going to set it for plea. Will the parties please introduce themselves for the record?
Thank you, Your Honor. Aaron Housefield on behalf of the people.
Good morning, Mike Mataloni on behalf of Ronnie Williams.
And Mr. Williams is not here today, but
No, Mr. Williams is not here. My office just contacted him and he texted back that it's on the 11th, as my secretary pointed out. That's today.
Yep, right.
And then he says he needs to get a ride. I know he's going to accept the plea offer made by the prosecution, which is a plea to the count 1 high VAC.
So should we just set it for plea today?
People do not oppose that, Your Honor.
Okay, we'll set for plea. What date do we have? So July 25th at 9 o'clock for plea. Okay, does that work?
Will that be in person, Your Honor, or on Zoom?
No, I think you should check. Does he have to check in the probation and all that?
I think that's best because, yeah, we'll refer him right to probation, probably the easiest.
Thank you.
I'd like to make sure he gets.
All right. So we'll set for plea on July 25th at 9 a.m. Anything else for the record in docket 22-00831, Ms. Housefield?
No, Your Honor, thank you.
Ms. Mataloni?
No, sir, but you know that she might be ready before you start hearing.
No, we're not ready.
All right, thank you, sir.
All right.
That's all
Good
for the
day.
record. You too.
Thanks, Sharon.
Yeah, of course.
Sir, on the Moto G Pure cell phone, if you could identify yourself for the record. That's you, sir.
Paul Martin.
All right, Mr. Martin, would you like the opportunity to speak with Ms. Robinson, the public defender, in your case in a breakout room before we get your motion started?
Yeah, I think that would be a good idea, Your Honor.
All right, I'm gonna put yourself and Ms. Robinson in a breakout room. All right.
Very good. Thank you.
Thank you.
I'll sit down.
So we're on the record in People versus State of Michigan versus Paul Martin. Although I don't think Mr. Martin has come back from the breakout room, has he?
No, I left him in there because I didn't know the situation with.
Let's see. And Mr. Cunningham, you're here for the Attorney General's office?
Yes, Your Honor, in regard to
All right,
Mr. Martin.
All right, we're gonna see if we can get Mr. Martin back from the breakout room. I have the public defender with me. And we'll put that on the record. All right. So let's go on the record in docket 220097. We'll start with the pretrial and then go from there just as an avenue of discussion. Will the parties please introduce themselves for the record?
Morning, Your Honor. May it please the court, Richard Cunningham, P 29735, Assistant Attorney General on behalf of the people.
Karen Robinson, Assistant Public Defender for Mr. Martin, who's appearing over Zoom.
And sir, you are Paul Martin?
Yes, Your Honor, that's correct.
Okay. And my understanding is that in relation to the pretrial and subsequent motion or vice versa, depending, that there have been some communications between the Attorney General's office and Ms. Robinson. And the question would be is would the court consider a Cobb's agreement in regards to the file? And that's my understanding. Is that true, Ms. Robinson?
That's correct, Your Honor. Mr. Cunningham and I have been in negotiations, and we've basically come down to an agreement that would be acceptable to Mr. Martin if the court would agree.
And Mr. Cunningham, is that a fair statement?
Yes, Your Honor. He's charged in a 4-count complaint, and the agreement would be that we would dismiss counts 3 and 4, the using a computer to commit crime, if he pled to counts 1 and 2, the malicious use of telecommunications system. If the agreement would also be that we would not advocate or request incarceration in any Cobb's evaluation.
And as I'm looking at the file, correct me if I'm wrong, Mr. Cunningham, I don't see a CCH along with the file. So what is your understanding as to, and this is purely for my edification only, the prior criminal history of Mr. Martin?
I have no record of any prior history, Your Honor. He's a resident of New York, and I have nothing in regard to any Michigan contact.
So let me do that. Let me do this in regards to this matter. I'd like to set this for plea with the understanding that the court is amenable to accepting a Cobb's no upfront jail in this. If we set it for plea, then we can talk about the Cobb's hearing. We can also we also won't be surrounded by other cases on the docket.
Sure.
And that might make it a little easier to go forward. Mr. Cunningham, would that suffice to go ahead and set this for plea?
Yes, Your Honor, I have no objections.
All right, so we'll get a plea date for this file.
He's currently set for trial on the 25th. I guess we could maybe keep that date and just move the time or whatever's amenable to the court.
And right now it's at 8 a.m. On the 25th.
Set it for plea at 8:30. So let's keep that date and set it for plea at 8:30 on that date.
8:30, sure.
So plea date on July 25th at 8:30. So Mr. Martin, you understand, instead of a jury trial, we're setting this for plea at 8:30 on July 25th. You understand that, sir?
I do, Your Honor.
Right, and via Zoom is acceptable because he lives out of state, and so we'll set that. We'll keep that date and set it for plea on that date, and whatever Cobb's issues we have, we can take care of that date. Mr. Cunningham has indicated there's no prior criminal history, so I see that less of an obstacle to the no upfront jail. So So let's set it for date on the 25th. All right, Mr. Cunningham?
Yes, Your Honor.
All right, Ms. Robinson, if that works, that's all in the files. 220975 and the accompanying motion will set for plea on July 25th.
Thank you.
Thank you. Mr. Martin, please keep in contact with your public defender, Ms. Martin, and we'll see you on the 25th.
Very good. Thank you, Your Honor.
Thank you.
Am I free to go, sir?
You are. Thank you, Mr. Martin.
Thank you. Have a good day.
Mr. Butler, you're back with us for your pretrial, so we'll await for the assistant prosecutor to come back and we'll put it on the record, okay?
Yeah, it closed the call. So, okay. Wi-Fi out.
All right, you're kind of breaking up a little bit. Ms. Sutter told us that there were some technology issues, but we'll see if we can put it on the record, all right?
All right.
Thank you, sir. Mr. Keen Anderson,
Yes, sir.
I'm going to put you in a breakout room with your lawyer from the public defender's office, Ms. Robinson. So you should get a prompt to go to a breakout room with her, okay?
Yes, sir.
All right, thank you, sir.
And Your Honor, I do see that Mr. Butler is back.
My Wi-Fi box got knocked out by my dog.
That's okay, Mr. Butler. Thank you.
You're all right. Do we need, I think Ms. Houseville should join us when we put that on the record, right?
Oh, I apologize. I couldn't see if she was in the room or not.
No, yeah, so we've got everybody, but she should be back here in a minute.
Perfect. Thank you.
Thank you, Mr. Fagelson. We're back on the record in docket 22-01684. That is people of the state of Michigan versus Martise A. Butler. Ms. Sutter, you've had the opportunity to speak with Mr. Butler in a breakout room?
Briefly, Your Honor, before his internet cut out.
All right. And my understanding is that there's no offer in the case at this point in time. Ms. Sutter, how are we proceeding?
At this time, Your Honor, I would ask the court to schedule us for a final pretrial.
All right, so we'll set for final pretrial on that same date, right? Is that is the, because you can do the 8th, but you can't do the 1st. Is that right, Ms. Sutter?
The reverse, Your Honor. I can do the 1st, but the 8th and the
okay.
22nd.
So let's do set for final pretrial on August 1st at 8:30. And then we'll set it for jury trial date on that 22nd date, understanding that we might have to move it.
Thank you, Your Honor.
On August 22nd at 8:30. at 8 o'clock. Yeah. So, Mr. Butler, you're set for final pretrial of August 1st at 8:30. That's the date you're supposed to be back in this Zoom room as you are today. And then the jury trial is set for August 22nd if it's not resolved on that date. You understand that, sir?
Yes, sir.
All right. If you have any questions, please keep in contact with your public defender, Ms. Sutter. Anything else for the record in 22-01684, Ms. Housefield?
No, Your Honor, thank you.
Ms. Sutter, anything?
Nothing for the record, Your Honor. Just Mr. Butler, please give me a call this afternoon or tomorrow morning.
Okay. I need your number. I think I need your number.
I'll put it in the chat.
Okay, thank you.
All right. Thank you.
Thank you.
Ms. Sutter, what other cases do you have for us at the 10 o'clocks?
Yes, Your Honor. I have Kathy Hunt and Brett Marshall, both of whom are either in the Zoom room or in the courtroom.
So we'll go on the record in docket 22-01453. That's people of the state of Michigan versus Kathy S. Hunt. Will the parties please introduce themselves for the record?
Thank you, Your Honor. Erin Housefield on behalf of the people.
Good morning, Your Honor. Assistant Public Defender Lauren Sutter on behalf of Ms. Hunt, who is present via Zoom.
And you are Kathy Hunt, ma'am?
Yes, I am.
All right, you can hear me all right, Ms. Hunt?
I can.
All right, this is the time set for a pre-trial. Ms. Housefield, how are we proceeding?
Thank you, Your Honor. At this time, there are no offers on the file. I defer to Ms. Sutter.
Ms. Sutter?
Thank you, Your Honor. I had not received word from Ms. Housefield about any offers being made, whether one being made or none being made. At this time, I also do not have any tickets or reports for this file, so I believe I'm going to need to ask for an adjournment, and I am having someone from my office file a supplemental discovery request for all of that material.
Any objection to a adjournment for discovery purposes?
No, Your Honor. And in fact, the reason I had not conveyed anything to Ms. Sutter is that I was not aware that she was on the file, which also explains the lack of discovery. So.
Right. All right, so we'll need a second pretrial date for discovery for Ms. Hunt's file.
August 1st at 9.
August 1st at 9 o'clock.
Thank you.
Thank you, Your Honor.
So Ms. Hunt, you recognize you need to be back here at this court on August 1st at 9 o'clock. And everybody should have the discovery that needs to take place before the attorneys can meet on your case. Do you understand that, ma'am?
Yes, I do.
All right. If you have any questions, please keep in contact with your attorney, Ms. Sutter, from the Public Defender's Office. Anything else for the record, docket 22-01453 from the people?
No, Your Honor, thank you.
Ms. Sutter, anything?
Nothing, Your Honor. Thank you.
All right.
Ms. Hunt, you're free to leave the Zoom.
Thank you.
So, okay, on the record,
Actually, Your Honor, would it be possible to do Stewart first and then I can do a breakout room with Mr. Medina?
sure.
Thank you.
And so that's Mr. Stewart. You can come on up. So we're on the record in docket 22-00287. Time set for a sentence and a restitution hearing on this matter. Will the parties please introduce themselves for the record?
Your Honor, Erin Houseworth on behalf of the people.
Good morning, Your Honor. Melissa Patrick on behalf of Mr. Stewart, who is here to my right.
And sir, you are Andrew Stewart?
Yes, sir, Your Honor.
All right. Ms. Housefield, how are we proceeding today?
Thank you, Your Honor. I will note for the court, I am standing in, this is originally an Adam Pfeiffer vertical case. I'm standing in for Mr. Pfeiffer today. My understanding from the last time that this matter was up, that defense counsel indicated to the court that they may be moving to withdraw the plea, as there are some recommendations that are inconsistent with the plea agreement. I will note for the record, however, that in order to withdraw a plea under People versus Killebrew, there has to be an indication by the court that Your Honor is not going to follow the plea agreement. So it's not an automatic just because the recommendation is inconsistent with the plea. So that's my understanding of why we are back here today. And I think that before we have any motions to withdraw and the court considers that, Your Honor would have to provide an indication on the record that it is not going to follow the agreement of the plea.
And what, I have a Killebrew agreement, but just for, so I can confirm that, what was the Killebrew agreement in the case?
We'll give you just a moment, Your Honor. I am looking through the file.
Based upon my memory, there was an agreement to no further upfront jail.
That is correct, Your Honor. I'm looking at the notes from the plea date of April 14th, and it does indicate that he's going to plead to count 3, and the people will be dismissing the remaining charges. The people move to dismiss the bond violation, and that there would be a Killebrew agreement to no additional upfront jail.
So that, no, so pled guilty to count 3, right? No further upfront jail, count 1 and 2 to be dismissed. And then this was set for an adjournment on the restitution hearing. And then, because I have restitution hearing set for today. And then whether I was going to follow the Killebrew agreement that was indicated by the court.
And as I mentioned, Your Honor, Ms. Beard is here she's the victim on this matter. So with regard to any restitution, she may be able to provide. I don't have any indication of restitution. I can inquire of Ms. Beard if that's why she's here, or if she's just here to watch the proceeding and speak on behalf of the sentence.
All right. So you could, ma'am, you're
Yes.
here on the Stewart case. You're Charlotta Beard.
Yes,
All right. And did you have restitution in this case, ma'am?
yes, excuse me, I did turn over the receipts
Okay.
from things that I owe from either the damage that he did personally. I do have those available that I can provide them again, need be.
I think
And
I have them. I think I have them, ma'am. I have restitution in the amount of $347.87.
and I'll be honest with you, I spent so much more money. That is still the only thing that's outstanding that I have to continue to pay. Anything that I've paid, I'll just chalk up and walk away from. However, that outstanding bill is what I'm requesting that he pays.
All right. The recommendation is suspend 180 days jail credit for 74 days. So essentially more jail time, which is why we're here. So Ms. Patrick, I'm reluctant to follow the Killebrew agreement as pursuant to the recommendation. And so at this time, did you have a motion to withdraw?
I do, Your Honor. And speaking and dealing with Mr. Stewart, we have reached an impasse as to moving forward. Not only is it finances, but the way that he wants to move forward. Initially, he stated that he did want to enter a plea to this, and we were initially going to withdraw the plea based upon the Killebrew agreement and whether you would follow that or not. But he has other information that he has shown me to where he wants to withdraw his plea regardless at this point. And I'm supposing that a motion would have to be filed under those circumstances.
Good. Ms. Houseville, any stance on this? This is Killebrew to know upfront jail. You're obviously familiar with the JOS. And I'm reluctant to follow the Killebrew at this point in time, based on the pre-sentence and the recommendation. Any comments on this?
Yes, I have a couple, Your Honor. Thank you. The first is that if the defendant were to withdraw because the court indicates it's not going to follow the Killebrew, I believe that that would be appropriate. But to withdraw a plea for any other basis at this time, there are specific rules that would have to be shown. A motion would have to be filed. The court rules specifically speak to withdrawing a plea before and after sentence. So I don't think that Ms. Patrick is allowed to stand here and say he has other reasons why he wants to withdraw this plea.
Right.
I think it's important that the record would indicate that it was being withdrawn pursuant to the Killebrew agreement. The second concern that I have, Your Honor, is I understand that the court has made a statement with regard to following the recommendations, but it would seem from Ms. Patrick's statement just now that when she says they've reached an impasse, it sounds as though she's not going to continue representing him. And if the court were to allow him to withdraw the plea, essentially starts the case over, and then there's going to be an issue with counsel, this is going to further delay the proceedings. This victim has been on board with this case for months, Your Honor, and this case has been drawn out because of this. And I think it would be unfair at this time. He had agreed to the plea agreement based on a specific Killebrew. If Ms. Patrick is going to withdraw and the case is going to start over, I have concerns that the victim is going to be delayed further in this matter, and that at some point the people will be prejudiced because of the time that has passed. So if Ms. Patrick indicates that she intends to withdraw the plea, Your Honor, I would ask this court to follow the Killebrew and not the recommendations, and allow the plea to stand and allow this case to be closed and for Ms. Beard to have this case be over.
Yes.
I'm gonna make, so I'll make inquiry to the victim in the case. Ms. Beard, for the record, you're Charlotta Beard, you're the victim in this case, correct?
Yes.
And it's my understanding that part of the agreement here was a Killebrew of no jail time in regard to this case in order to help resolve the case and the issues inclined in the case. Do you have any objection to the no upfront jail Killebrew? In order to, I should say that. So if I accept the upfront no Killebrew jail, then we can go right to sentencing because there's no reason for the defendant to withdraw their plea. That's essentially. So I'm really leaving it. I'm asking you, because that would be my fear. My fear is that you as the victim should have a say in this matter. And if you're good with that that agreement, I'm good with that agreement. If you're not good with the agreement, then I've got a problem with it.
Am I allowed to go to a breakout room with the prosecutor to discuss this for a moment?
Absolutely. Yeah, absolutely.
Can we do that, please?
So would you like to speak to Ms. Houseville on this matter?
Please.
All right. So Ms. Beard, I'm going to place you in a breakout room with Ms. Houseville, and we'll take a small adjournment in this matter.
Thank you.
All right.
Thank you.
Thank you, Ms. Patrick.
Yeah, no problem.
All right, Mr. Stewart. So would the person on the tablet please identify themselves? They can't, no audio? All right. Sir, on the fire tablet, you're Mr. Hurd?
Yes, I just got through. Yes, sir.
All right, I just have you connected. You're here for the 10:30.
Yep.
I'm gonna have to stand by. We've got some other files in front of you. So if you could stay in one place, that'd be helpful. All right, thank you.
No.
You're not on mute, so please mute yourself.
Mr. Hurd, if you can mute yourself, because the courtroom can hear you.
I think I'm on now. Oh, Zoom.
the Stewart matter.
Yes, Your Honor. Thank you.
All right.
Right over.
So we're back on the record in docket 22-00287. That's the people of the state of Michigan versus Andrew Stewart. There's been some discussion between the victim in the case and Ms. Housefield. I would indicate for the record that there is somebody here from the CARE program. That's Ms. Van Eck. And I'll state that for the record. Ms. Housefield, you've had the opportunity to speak with Ms. Beard in a breakout room. How are we proceeding today, or what's the status of the case?
And thank you, Your Honor. I have had the opportunity to speak with Ms. Beard. I guess the discussion really revolved around this idea of what no upfront jail means. And she was not understanding what that is as a legal concept. So I took the time to explain to her that no upfront jail just means that the court doesn't impose jail as part of the original sentence, but that at any point in the future, if there's a violation of the probation, the court may use jail as a punitive force for a sentence on a probation violation. Understanding that, Your Honor, the victim, Ms. Beard, is comfortable with the court following the Killebrew for no upfront jail. We spoke specifically about what a sentence would look like or could look like and what she would be interested in advising the court. And she told me that she would like to see him on probation for a year. She believes that the court oversight is important so that there's no further contact. She indicated to me that there has been a number of contacts. She's been receiving calls from private numbers. She's been receiving contacts from Mr. Stewart's family members. So she thinks that oversight by the court would help to change the behavior or at least hold him accountable. She would like to see him on a GPS tether with victim notification. And she would like the court to reiterate that there is to be no contact, either direct or indirect, by any family members or friends or anyone that would come on his behalf, either in person or on social media, telephone. Additionally, Your Honor, she believes that there is a history of drug use and that a lot of actions that he takes are as a result of using substances. So the people would also ask that the court, in addition to the standard no alcohol, drugs, controlled substances, that the court as part of probation would impose testing to ensure compliance with a no alcohol or drugs provision.
May I have a word, Your Honor?
Hold off on that because your counsel's right here. I want to make sure you're still represented by counsel. So the time set for sentence in this matter, the Killebrew is to no upfront jail. And rightly so, there are reasons that the court would consider such a Killebrew in a case, especially with the victim here. I understand the need for resolution in the matter. But I've read the pre-sentence investigation and I've read the CCH, and it is problematic for me to give him a Killebrew of no jail. So I'm not going to tie myself to the Killebrew agreement of no jail. I'm just not going to do it. So you would have the ability to withdraw your plea in this case if you want. Let me finish and then you can talk. You would have the ability to Killebrew no jail. I read your CCH, sir, and there's multiple assaultive crimes on this.
I understand.
Yeah. So I'm not going to tie myself to Killebrew no jail, which gives you the opportunity to withdraw your plea in this matter. That being said, counsel also has to make a determination whether they can continue to represent you. This places a real problem with the file. Ms. Patrick?
Your Honor, I would like to renew my motion to withdraw.
Okay. And I do think, sir, within your rights is to withdraw your plea at this point in time if you choose. Now, now understand you're saying whatever you say to me, I want to make sure that you're saying in front of counsel and counsel's moving to withdraw. So, I mean, there's many variables here that put you at risk.
I understand, Your Honor, but I was told to let you know by an officer that I encountered while I've been out on tele to make you aware of what happened to me.
All right, well, let's not get into the facts of the case, all right? I mean, you've had plenty of time to get into the facts of the
Surrounded by
case.
police
All right.
with guns.
That's right. And I don't know the nature of what was told to you. And quite frankly, I don't want to know the nature of what was told to you by an officer at the scene. Trust me.
Thank you.
You do not want me to know that.
This is a different incident, sir.
Well, even more so than we shouldn't be discussing it here.
Okay.
Even more so. All the reason not to discuss it as not relevant to this matter.
Sorry, Your Honor.
No, you're fine, Mr. Stewart. I understand this is a difficult process. But I understand that there are things about this case that I don't know. I understand that. All right. But I've looked at the Killebrew agreement. I know the plea was taken by another judge. It wasn't taken by me. We did adjourn it for a Killebrew hearing restitution. We have restitution set. We've had discussions between the prosecutor and the victim in the case, which I understand the prosecutor is trying to set an agreement that they see as fair. I understand that, but I'm not going to tie myself to the Killebrew agreement in this matter, knowing that creates problems for the case. So I'm going to ask Mr. Stewart today, would you like to withdraw your plea, knowing that I am not agreeing to Killebrew no upfront jail?
I'm so confused right now at this point, Your Honor. I don't know what to do.
Since I have not been removed yet, I will speak for Mr. Stewart. He would like to withdraw his plea today.
All right. Okay. So you're understanding the court is refusing to follow the Killebrew agreement and no upfront jail, and counsel, before she's made a motion to request not to, but she's indicating that at this point in time, you wish to withdraw your plea with the understanding that I refuse to tie myself to a Killebrew agreement between the lawyers and no upfront jail.
So, Your Honor, I need a little help here.
Your counsel's right there. I've not removed your counsel yet.
Ms. Patrick, please, I need a little help here.
I think she just did. I think she
I'm not fully understanding on, I know you're saying that she want to remove herself from helping me.
Right.
But then where do I go from there? Because I need representation.
You're going to have to retain counsel or apply to the public defender's office.
And where did that leave me? Still out on teller or incarcerated?
Correct. That's exactly, the case has not resolved itself.
Would I be able to just get a couple extra weeks with Miss Patrick so I could try to get the money to pay her what she's actually?
That's between yourself and Miss.
He's not gonna pay.
Well,
Can we just move forward?
Sure. Okay. So, Ms. Patrick, are you asking to be removed from the case?
That's correct.
All right. Ms. Patrick, I'm removing you from the case. Mr. Stewart, and indicating that I'm not taking your, I'm not sentencing you today. You're withdrawing your guilty plea, or else I would be sending you to jail. Okay. So you're withdrawing your guilty plea. I accept your withdrawal of the guilty plea. I'm going to set this for pretrial today. It is incumbent upon you for two things now. Okay. You need to retain counsel.
okay.
All right. And you need to give the new counsel the date that we're setting the pretrial for. All right. Second, if you can't retain counsel, you have to go to the public defender's office to get counsel. All right. Those are on company. The new date is going to be significant because this case has already developed a life of its own, and it's not going to go any further. All right. It's not going to go any further. We're going to have a pretrial, and then we're going to set it for jury trial. Okay. It appears we have a victim on board.
Yes, absolutely.
Who has support. All right. And so, Ms. Housefield, any comment?
Yes, Your Honor, this was originally a felony matter, so it would have to be set for PCC and prelim as opposed to pretrial and jury.
You're absolutely right. You're absolutely right. So we are going to set this for a probable cause conference on the felony matter. because it started out as a felony, okay? And we're
Excuse
gonna
me, Your
set
Honor.
it for-
I'm sorry.
Correct. Let me set the dates and then I'll have you discuss any options with Ms. Housefield, all right?
Yeah, my question is, if he's withdrawing the plea, does all of those other charges still come back and stand?
Yes,
Okay, okay.
yes.
Then I can contact Ms.
So-
Hoffman today.
So the probable cause conference is set for,
July 21st at 8:30?
okay, July 21st at 8:30. And the prelim date?
At 8:30.
July 28th at 8:30 for the preliminary examination. You're going to receive notice of that, Mr. Stewart, and it's incumbent that you contact, when you go and contact a new lawyer, that you give them those dates, all right? July 21st at 8:30 and July 28th at 8:30, because those are the dates that they're going to be responsible for being here representing you and then going to prelim, all right?
Yes, sir.
You're still under your current bond conditions. Those haven't changed at all, all right? This case is brand new again, all right? Anything, Ms. Housefield?
Your Honor, and I apologize again, this is not my case. I would just like to confirm for purposes of bond, is he on a GPS tether with victim notification?
Yes,
And could the court just reiterate the no contact so that it is
Yes.
clear in open court what the expectations are?
so, so Mr. Stewart, under the current free trial conditions of bond, it is incumbent that you have no direct or indirect contact with the victim.
Yes, sir.
That means that people shouldn't be contacting the victim on your behalf. That means that you shouldn't contact the victim. And that means that if you're walking down the street and you see Miss Beard, you run as far away from Miss Beard as you can. The onus is on you for everything, all right? If that's in a violation, we will violate you. And I'll tell you right now, with your history, I will put you in jail, all right?
Thank
So
you.
what's my rights?
Okay,
What is my
your
right?
right is to, you're right now, the main right you have is to get a lawyer. Okay, you have,
While
and
I'm out on bond.
but you're out on bond, get a lawyer or call the public defender's office and we can give you that number.
It's already encountered 10 police officers because she called in on me about a televiolation.
Mr. Stewart, you do not want to tell me about that.
They
Yeah.
gave me the,
Mr. Stewart, you do not want to tell me those facts.
This
right?
is the
How
problem
about
that I
this?
have. I don't know that he can follow rules and it affects my
All right.
safety. He's arguing with
Right,
you.
I know, Miss Beard, we're fine today. Mr. Stewart,
Okay.
just understand, the big thing here is for you to get a lawyer before July 21st.
okay.
Right, and then and share that date, all right?
Okay,
And the onus is on you to stay away from the victim. You understand that?
right. I'm so in fear of my freedom.
Like
Here, I
you're
need
not
to-
gonna, okay, just so you understand, Mr. Beard, if you don't stay away from the victim,
Staying away.
we'll take care of your freedom, all right?
I'm staying away. I
Okay.
haven't been involved.
All
with
right,
it.
so let's just leave it at that, all right? Okay, let's leave it at that. Ms. Patrick, you're no longer in the file, okay? And that's all for the record in docket 22-00287. We will see you in court on July 21st, sir, with counsel, all right?
Okay,
All
thank
right.
you, Your Honor.
Ms. House,
No.
did you want to meet with Ms. Beard or is she already gone?
Did you unmute that? Ms. Beard, I will have either Alish or Adam follow up with you after today. Is that okay?
I can't hear.
Are we muted now?
No, we're not muted. Ms. Beard, can you hear me?
No, I cannot.
No. Ms. Beard, can you hear me now?
For whatever reason, I have lost audio. Let's see.
All right,
Well, we will call her.
all right, all right.
We can check.
Hello?
If you want to let me know as well, I can try to relay the information if that's helpful.
I can hear now.
Okay.
Prosecutor's
Hi,
office is
Maddie, how
gonna
are you?
contact-
Yeah. Pardon?
The prosecutor's office is going to contact you in regards to the case, but essentially the case is restarted all over again, all right? So you'll have. Ms.
Absolutely, and I will
Gallagher
do my
or-
best to make sure I'm there and fully cooperate and comply.
All right, prosecutor's office will be in contact with you. You're all set. Thank you, Ms. Van Eck, for your appearance also.
Thank you. Thanks, everyone. Have a good day.
You too.
Bye-bye. How am I getting out of this? It won't let me out.
Ms. Stewart, you're all set for today, or Ms. Beard, you're all set for today.
We are on the record in docket 22-01268. People of the state of Michigan versus Christopher K. Fisher. Will the parties please introduce themselves for the record?
Thank you, Aaron Musket, on behalf of the people.
And Assistant Public Defender Scott Nickel on behalf of Mr. Fisher, who is not present.
That's my understanding. This is the time set for a no contest plea in the matter, and it is now 11:30. This was set for 10 o'clock. Ms. Housefield, how are we proceeding today?
Thank you, and the people would request a bench warrant bond forfeiture.
Any comment, Mr. Nickel?
And no, I would leave that to the discretion of the court. I would note that the last time we were in court, he was present over Zoom. For some reason that I do not know yet, his Zoom connection disconnected, and that's when the court set this date.
Right, and this is, yeah, I have not essentially, I have this set for live plea, so I did indicate, but I will authorize a bench warrant and bond forfeiture for Mr. Fisher. And we did set this for plea at that time.
Yes.
Okay, so that's all for the record in docket 22-01268. Anything else, Ms. Housefield?
No, Your Honor, thank you.
Mr. Nickel?
No, Your Honor, thank you.
All right. We're on the record in docket 22-00795. People of the state of Michigan versus Brett Aaron Marshall. Parties, please introduce themselves for the record.
Thank you, Your Honor. Aaron Musket, on behalf of the people.
Good morning, Your Honor. Assistant Public Defender Lauren Sutter on behalf of Mr. Marshall, who is seated to my right.
And sir, you are Brett Marshall?
Yes.
All right. This is the time set for sentencing in the matter. I've received a pre-sentence report on the matter. I'm assuming, Ms. Sutter, you've received it and gone over it with your client?
I have, Your Honor.
Any deletions, additions, or corrections?
I believe one addition, Your Honor, in the employment section, it is still correct that Mr. Marshall is working full-time at Meyer Warehouse. He has picked up a second job working at Little Caesars. That's between 35 and 40 hours a week, roughly.
Thank you. I'll make that addition. Anything as to allocution, Ms. Sutter?
Thank you, Your Honor. I have reviewed the recommendation from probation with Mr. Marshall, primarily the period of time that they are recommending, the 12 months, as well as all of the other additional requests they are making of him. He has no objection, I believe, to taking these courses they've recommended. He has expressed to me that he's taken them before, and so would perhaps be interested in taking alternative ones, so he's at least getting a different experience, although he understands that that's not quite possible with probation. The primary thing he and I have discussed is the no contact order with Ember Marshall, which has been requested by probation. Your Honor, Mr. Marshall is already involved with CPS, the family, and Samaritas. He tells me Samaritas is currently observing his interactions with the child, including at this stage, they have allowed supervised visitation. They are holding off on that while this case is still pending. And so I recognize, given the underlying facts of the case, that probation is asking this no contact order. However, I would ask the court to defer to the family court and Samaritas in terms of visitation, as they are, I suppose in my opinion, Your Honor, an authority already in position to observe the situation, to take into account the best interest of the child, and in a better position to have the kind of oversight of what's going on and to recommend what is the more appropriate visitation or non-visitation rights between Mr. Marshall and his daughter.
Thank you. Any comment on the no contact order with the child from this house?
Thank you, Your Honor. I just want to confirm that this, who is on Zoom is who is on Zoom, correct?
Correct.
My office had reached out to the victim's mother to make sure that she did not wish to appear presented today. So,
all right.
Thank you. Yes, Your Honor, I don't disagree with Ms. Sutter that the child CPS and the court system already in place would be an appropriate party to oversee that. I would just ask that perhaps some time pass first. I know traditionally in cases involving children or child abuse, Your Honor, that Your Honor will have a period established, a couple of months perhaps, when the person is on probation, and then probation works with CPS in order to ensure a smooth transition, and that what is being asked of the defendant in the criminal matter is occurring before that no contact order is lifted. And if the court is inclined to do that, I believe that would be appropriate.
Thank you.
Your Honor, I apologize. I did forget one thing in my elocution, if I might briefly go back.
Sure.
In regards to the drug and alcohol testing that is recommended by the random PBTs that's recommended by probation, I see nothing in this underlying file for Mr. Marshall's criminal court history that indicates a significant problem with alcohol or substance abuse. He expresses to me that he doesn't drink alcohol. In addition, he also tells me that Samaritas is also doing urinalysis tests for drugs and alcohol for him already. So he is already under drug and alcohol testing with the family courts. So I don't know that kind of double testing is necessary, and is quite frankly for Mr. Marshall a financial, a quite serious financial inhibition. So I would just ask the court to remove the requirement for random PBTs and urinalysis testing.
Thank you, counsel. Mr. Marshall, with the understanding that your counsel has spoken on your behalf, do you have anything to indicate to the court prior to sentencing?
No.
Well, I agree with the pre-sentence report in regards to the probationary matter. You also have to, it's also the understanding that we've discussed that there are conflicting goals here between the two courts. The Child Protective Services in the neglect abuse case is in order to make sure to reunify the family and do it in the safest way that they know how. The probation court is to make you responsible for your domestic assault case. And there are two different goals, so they're at odds right now on some level. In my short tenure here, it's happened more than once. What I prefer to do is to give deference to begin with to our probation department, say 30, 45 days to get it set so you know exactly what you need to do, so we don't interfere with your employment, so you're on board, and then let the onus be with Child Protective, with the neglect abuse, so they can give you supervised visitation as we go on. because I understand their goal and it's a worthy goal. Okay, you want the ability to visit your child, and we want to make sure that we recognize the goal of reunification of family. So that is essentially going to be my order. I don't see anything in the. I don't see anything that would indicate that that urine substances is necessary. I just don't see it in the file. And if that's part of family reunification, do everything possible to reunify your family. All right. I'm not going to make it an order of this court. All right. So I'm gonna accept the JOS or the pre-sentence recommendation. I am going to give you some fines and costs because I think it's necessary in this matter. I'm not going to go crazy in that regard, but I'm going to make sure that you understand that this case is significant. And you've been through the domestic assault classes one time, and for whatever reason, it didn't stick. Okay. So we're going to make sure that it sticks this time, right? For whatever reason, I want to make sure this doesn't happen again. Because the next time it happens, it just aggregates. It turns from a 1 year to a felony, and then you got more problems than you know what to do with. And that doesn't help you, and it certainly doesn't help the court system. You understand? So I'm going to set fines and costs at. So I'm going to sentence you on count 1, your guilty plea to domestic assault. I'm going to suspend 93 days in jail beginning on July 11th. Credit is given for 1 day previously served. I'm suspending the rest of the jail time in this matter. You've done 2 things that sets you in favor of this. One is you are gainfully employed, and then you picked up a second job where you're gainfully employed. That gainful employment is a big deal here. All right, it's important. It's important for you. It's important for the reunification of your family. I'm going to set fines and costs at $100 fines and $100 costs. I'm required to do a crime victims' rights fee of $75, minimum state costs of $50. I'm going to put you on probation for 12 months. Okay, that's $30 per month, which is $360 total. The 769-4A is granted. Your We got a bunch of files. Let's go 19-1205, 206, and 207. We'll start with 205. And that is people of the state of Michigan versus David Keene Anderson. Will the parties please introduce themselves for the record?
Thank you, Your Honor. And if Your Honor wouldn't mind calling all three cases together, our disposition is going to be the same for all.
Perfect. So I'll call to the record then 19-205, 19-01205, 19-01206, and 19-01207.
Thank you, Your Honor. Aaron Hospital on behalf of the people.
Aaron Robinson, Assistant Public Defender on behalf of Mr. Keene Anderson.
And sir, you are David Keene Anderson?
Yes, sir.
All right, you can hear me all right, Mr. Anderson?
Yes, sir.
All right, this is the time set for a free trial on three files. Ms. Housefield, how are we proceeding?
Thank you, Your Honor. An offer has been conveyed. Ms. Robinson and I have been in communication regarding this. At this time, it's my understanding that they wish to have the matter set for final pretrial and jury trial. That offer, Your Honor, will remain open through the final pretrial.
And that's an accurate statement, Ms. Robinson?
It is.
All right. So we will set this for final pretrial and jury trial. Do you have a date for final pretrial?
August 1st.
9 o'clock. And for jury trial?
August 8th.
At 8 a.m. So the dates for all three files will be set on August 1st at 9 o'clock for final pretrial and for jury trial on August 8th at 8 o'clock. Anything else for the record, Ms. Housefield?
No, Your Honor, thank you.
Ms. Robinson?
No, Your Honor.
All right, so Mr. Keene Anderson, keep in contact with your public defender, Ms. Robinson. your first date is a final pretrial set for August 1st at 9. And then the second date is a jury trial set for August 8th at 8 o'clock. All right,
Yes, sir. Yes, sir.
All right. That's all for the record in these 3 files.
All right, and I'm free to go.
Anderson.
All
You're
right.
free to go, Mr. Dean Anderson.
Okay, thank you. You guys have a good day.
You too. Let me make sure I got those dates for every file. All right. And is that you, Ms. Robinson?
It is.
All right. So we're on the record in docket 21-00817, people of the state of Michigan versus Jeffrey Medina. Will the parties please introduce themselves for the record?
Thank you, Your Honor. Aaron Housefield on behalf of the people.
Erin Robinson, Assistant Public Defender on behalf of Mr. Medina.
And sir, you are Jeffrey Medina?
Yes, I am.
And you can hear me all right, Mr. Medina?
I can. My apologies for a lot of much. Right now, I just had a power outage at my house and my phone was down to 4%. So I got kicked out of the room. I had to go and borrow a phone in order to match. I
Well,
apologize.
whatever you got going is working because we can hear you. All right, sir?
Okay, thank you.
Ms. Housefield, this is the time set for a pretrial in the matter. How are we proceeding?
And thank you, Your Honor. I have had the opportunity to speak with Ms. Robinson. An offer was conveyed late yesterday. My understanding in discussing the matter with Ms. Robinson that they would like an adjournment so that the defendant has time to consider the offer, perhaps 30 days, and the people don't object to that adjournment.
Okay, so
And
Ms. Go
I
ahead,
guess,
Ms.
I'm sorry. I suppose, Your Honor, as opposed to an adjournment, it's really having it set for a second pretrial.
All right. So adjournment for second pretrial, offer's been made. Ms. Robinson, is that your understanding?
It is.
All right. So we'll need a second pretrial date, 30 days out or so, 21 days out or so. August 1st at 9 a.m. Ms. Robinson, may I briefly inquire Mr. Medina so he understands that that's the date set for the next hearing?
Yes.
Mr. Medina, you understand that the next hearing in this matter is August 1st at 9 a.m. Now that the offer has been conveyed to you, you'll have some time to consider that offer and to be in contact with your attorney, Ms. Robinson.
Okay, thank you.
All right. So August 1st at 9 a.m. for second pretrial, offer's been made. Anything else for the record in 21-00817? Ms. Housefield?
No, thank you, Your Honor.
Ms. Robinson?
No, Your Honor.
All right. Thank you for your appearance today. Mr. Medina, you're free to leave the Zoom room.
Thank you.
record in all three. I just want to make sure I got them all here. I'm not sure what this is a tip, you know? So, Mr. Hurd, you may want to unmute. Mr. Hurd? Yeah, you're still on mute, so you may want to unmute. There you go, sir. All right, we're on the record in three files, docket 22-00186, 22-00821, and 22-01397. Will the parties please introduce themselves for the record?
Thank you, Your Honor. Aaron Housefield on behalf of the people.
Aaron Robinson, Assistant Public Defender on behalf of Mr. Hurd.
And this is the time set up on a pretrial on those three files that have been called. Ms. Housefield, how are we proceeding today?
Thank you, Your Honor. It's my understanding that Ms. Robinson was just retained and at this time does not have discovery. I imagine she would be seeking a short adjournment for discovery purposes, and the people have no objection.
Ms. Robinson?
Yes, Your Honor, that is accurate.
All right. On all three files, Mr. Hurd, it appears that you've just been appointed your public defender, which is Ms. Robinson. And so we're going to adjourn these matters in order for discovery purposes. We'll get a new date for you. All right, sir?
All right.
All right. Hang tight there and we'll get a new date for all three files.
All right.
So.
And Mr. Hurd, is your phone number still the ends in 7651?
What's the number? The number is 517-721-0207.
Okay, great. I'll update that.
All right, Mr. Hurd. This has been set for a new date on all three files for pretrial in order to comply with some discovery purposes, and the public defender was just appointed on your case. So your new date in this Zoom atmosphere will be, for all three files, will be August 1st at 9 a.m. You understand that, sir?
August 1st at 9 a.m.
August 1st at 9 a.m.
Got you.
If you have any counsels, please keep in contact with your public defender, Ms. Robinson. Anything else for either of these files, 22-00186, 22-01397, and 22-00821. Ms. Housefield?
No, thank you, Your Honor.
Ms. Robinson?
No, Your Honor.
All right, Mr. Hurd, we'll see you on August 1st. Have a nice day.
All right, you too.
Sir, you're Dylan Clark?
Correct.
All right. The attorneys are meeting on your case right now, so just stand by, all right?
Yes, sir. Is my parents here?
I don't have anybody in the Zoom room or the courtroom, but this is also being streamed on YouTube, so they might be able to see it there.
Okay.
Okay.
Ugh.
Well, yeah. Hey, I got 21 years ago, I still. This is because we. I know. Yeah. It's the mask. All right. Hey, that popcorn is fresh. I made it. Go eat it. So we're on the record in docket 22-01130. That's people of the state of Michigan versus Nicholas A. Jetton. Will the parties please introduce themselves for the record?
Thank you, Your Honor. Aaron Housefield on behalf of the people.
Good afternoon, Your Honor. Assistant Public Defender Stephen Feigl, appearing on behalf of Mr. Jensen, who's present to my right, Your Honor.
And sir, you are. Sorry, see, you're gonna go and have a seat right here, sir. Nicholas Jetton? All right, thank you, sir. Ms. Housefield, how are we proceeding today?
Thank you, Your Honor. This is the time set for a competency review. It's my understanding that the defense does not wish to challenge the report and would be stipulating to the findings of Dr. Jennifer Whitmore in the report dated July 5th, 2022, which found the defendant to be competent. The people would also stipulate to those findings and ask the court to enter an order consistent with and adopting the findings of Dr. Whitmore.
Is that your understanding, Mr. Feigl?
That is, Your Honor, a couple other things though, and Your Honor,
All right.
We are considering and looking at this, sending this young man to the drug court. I do know the referral has been made, and I believe we have the discussion with Mr. Tusco. One other thing to add, Your Honor, I think we talked about this at the last hearing. Our office is still making the decision whether we're going to send this case to conflict counsel. I do know we have multiple files already up in front of Judge Aquilina, I believe that has, or no, Judge Jane, excuse me, that has a bunch of lawyers in my office as well as Chill Yang. I expect some sort of answer to that this week. Advise the court according depending on which direction our office chooses to go. But yes, we do stipulate the findings of this report.
All right. And I've had the opportunity to review the report. I understand that the recommendation was made for competency. So that to stip to the competency report. And an order will be prepared by this court. We'll get a new preliminary exam date for our purposes, with the understanding that the twofold. So new prelim date is July 22nd at 8:30. And the conflict issue with the public defender's office is to be looked into, or continue to be looked into. And also the looking into the drug court option. So the new date for preliminary examination is July 22nd at 8:30, and both sides step to the report done for this matter. Anything else for the record on docket 22-01130? Ms. Housefield?
No, thank you.
Anything, Mr. Feigl?
No, Your Honor, thank you.
All right. Thank you, Mr. Jutton. Oh, he's got two files, right?
Yeah.
But let me call the second one and we'll just refer the same, all right? Because I don't know if I called them both. So we'll also go on the record at 21-02844. Parties introduce themselves for the record.
Thank you, Your Honor. Aaron Housefield on behalf of the people.
Good morning, Your Honors, or good afternoon, Assistant Public Defender Stephen Feigelson. Appearing on behalf of Nicholas Jensen, who's seated to my right.
And you are Nicholas Jetton, sir? All right, similarly in this file, it's my understanding that a report is going to be stipulated to.
Yes, Your Honor, thank you. The people would, and then the defense counsel would stipulate to the report of Dr. Whitmore from July 5th of 2022, finding the defendant competent. The people would ask that the court adopt an order, or I'm sorry, enter an order adopting the findings of that report.
And then Feigelson, under the same conditions of the prior file, that's correct?
Yes, Your Honor, that is correct.
I will set the prelim date for this file for July 22nd at 8:30. The court will prepare an order to the stipulation. Anything else on this file, 21-02844? Ms. Housefield?
No, thank you, Your Honor.
Anything, Ms. Feigelson?
On both files, I don't know if there's been a bond set or if we may address bond this morning.
I think you can address bond. One bond has what was 2,500 cash or surety on 22-01130. I'm not sure. On this one, it was also set at 2,500 by Judge Ward. I have this on 21-284. So this one also.
Tell me there's no bond at bed. Isn't there funding agreement? No. Yeah. Only bond is, Your Honor.
It's a cash surety of 2,500 set by Judge Ward. Anything, Ms. Houseman? All right.
25,000.
21-02844. All right, we're on the record in docket 21-03153. That's people of the state of Michigan versus Dylan Karn. Will the parties please introduce themselves for the record?
Thank you, Your Honor. Aaron Housefield on behalf of the people.
Good afternoon, Your Honor. Assistant Public Defender Lawrence on behalf of Mr. Karn, who I believe is present with us via the Polycom system.
Sir, on Polycom, you're Dylan Karn.
Correct.
All right. And you can hear me all right, Mr. Karn?
Yes, sir.
All right, thank you. This is the time set for a pre-trial and a PA 53 violation. Ms. Housefield, how are we proceeding?
Thank you, Your Honor. It's my understanding that defense counsel has not had the opportunity to speak with her client, and before we proceed, she would be asking for a short breakout room.
All right, so Mr. Karn, I'm going to put you in a breakout room with your public defender, Ms. Sutter. All right, so you'll have the opportunity to speak about some of the issues in this case. Right, that freaked me out seeing you there, Lauren, and then
Sorry.
and then yeah. So let me put you in. I'll put you in breakout room 1 with him.
Okay, thank you.
Thank you.
You're welcome. You're welcome. I think they're here on the Karn matter.
Okay.
Great.
She have made application and needs more information. So at this point.
Understood. Thank you.
So we're on the record and docket 21-01123. People of the state of Michigan versus Yolanda R. Owens. This is the time set for a pretrial in the matter. It was scheduled at 10:30. It is now 12:30 or 12:25. Ms. Housefield, how are we proceeding today?
Thank you, Your Honor. At this time, the people would ask for a benchmark bond forfeiture in the matter.
People have asked for a benchmark bond forfeiture. This is an assault and battery assaulted case, so there's no hold put on it. D is FTA for about 2 hours, so we'll issue a benchmark and bond forfeiture in the matter.
Thank you, Your Honor.
That's all for the record, 21-01123.
Okay. So are we okay with a 1-for-1 offer?
We're on the record in docket 21-03153. The State of Michigan versus Dylan James Carn. Will the parties please introduce themselves for the record?
Thank you, Your Honor. Aaron Housefield on behalf of the people.
Good afternoon, Your Honor. Assistant Public Defender Lauren Sutter on behalf of Mr. Carn, who was present via the Polycom system at ICJ.
And sir, you are Dylan Carn?
Yes, sir. Correct.
All right. All right. You can hear me all right, Mr. Carn?
Yes, sir.
All right. Ms. Housefield, it's time set for a couple matters in this case. How are we proceeding?
Thank you, Your Honor. If you could address the pretrial matter first.
Okay.
It is my understanding an offer has been extended and that the defendant wishes to accept, and that is to plead guilty to an added count 3 of domestic violence pursuant to 750.812. The maximum penalty on that, Your Honor, is 93 days and/or $500. There is a Killebrew agreement to a sentence under 7694A. In consideration for that plea, Your Honor, the people would move to dismiss counts 1 and 2. It's my understanding from speaking to the victim, Mr. Stott, that there is no restitution, despite the fact that count 2 is a malicious destruction of building charge.
Okay.
That would be it with regard to the plea, Your Honor.
So I'll restate my understanding of the offer on the record, and then Ms. Sutter, you can indicate that if I got it right or not. The offer at this point in time is to plead guilty to count 3 of domestic assault under 750.81 parents 2. That being the 93-day misdemeanor and/or $500. Sentence would be Killebrewed to 769-4A status. Pursuant to that, dismissed counts 1 and 2 of this file will be dismissed. The A and B and the MDOB. And currently there's no restitution on the malicious destruction of building. Is that your understanding, ma'am?
That is correct, Your Honor. And in discussions with Mr. Carn, I believe that would be entered in the consideration or perhaps the hope that the bond violation, the P53 violation would be dismissed.
I can address that now as well, Your Honor, if you'd like.
Thank you.
Thank you, Your Honor. I do understand that it is an order of the court and it is not mine to dismiss. However, in speaking with the victim, Mr. Stott, who's present in the courtroom today, along with Ms. Feldpash, who is the victim's mother, the defendant's mother, thank you. Ms. Feldpash and the victim reside together, as does the defendant. And so while this was a technical violation in the sense, Your Honor, that the defendant was present at the location where the victim was, he was there essentially by invitation of his mother. And so we have talked about some of the issues that occur when she invites him there, but we have a victim who resides in the same location. And we are working, in fact, Ms. Sutter and I have spent some time today speaking with Mr. Stott and Ms. Feldpash and talking about some of the different options and services that the public defender's office can provide to help him find alternative housing. But so this was a technical violation, Your Honor, but one that I think would be difficult for the court to proceed on, given the facts as I have described them. So it would be the people's suggestion to Your Honor that perhaps a dismissal of that violation with an understanding that everyone is now understanding of what the expectations are of the parties and that the defendant will not be invited back by the mother because the victim will continue to reside.
All right, so let's do the pretrial and then we'll address the PA53 violation. And so, sir, so Ms. Sutter, may I inquire of your client concerning the plea?
Yes, Your Honor.
All right. Mr. Carn, you understand that the agreement is for you to plead guilty to count 3 in this matter, which is domestic assault. Do you understand that, sir?
I do, Your Honor.
And that's pursuant to 750.81 parents 2. The maximum penalty for that is 93 days and or $500. Do you understand that, sir?
I do, Your Honor.
All right. There's also Killebrewed agreement that you be sentenced under the guise of 769-4A status. Do you understand that, sir?
Correct.
And you've been explained what that means by your attorney, Ms. Sutter?
Yes, I did.
Okay. If I accept your plea, you will not have any trial of any kind in this matter. So I want to make sure you know what kind of rights you're giving up in regards to this guilty plea. So in trial, you would have the right to have witnesses called in your defense. You have the right to cross-examine all witnesses. You'd have the right to testify or remain silent without an inference being drawn from your silence. You have the right to the presumption of innocence, and you have the right that the people of the state of Michigan would prove all elements of the crime beyond a reasonable doubt. Do you understand that, sir?
Correct.
And you are represented by Ms. Sutter, and Ms. Sutter would have the opportunity to contest any charges brought against you in the matter that I previously described. Do you understand that, Mr. Karn?
Yes, I do.
And you are agreeable to waiving your rights to trial in this matter. You're pleading guilty because you are guilty.
Correct.
All right. I'm going to bring your attention back into count 3, the amended count 3. Oh, yeah, I will. Thank you. Thank you. So I'm going to have you raise your right hand. Do you solemnly swear to tell the truth, the whole truth, and nothing but the truth under penalty of perjury?
I do.
All right. I'm going to bring your attention back to, and it would be the amended count 3 in this matter, which occurred on November 17th of 2021 at the offense location of 2121 West Miller Street, City of Lansing, Ingham County. Were you present on that date at that time, Mr.
Yes,
Carter?
I was.
And at that time, did you have the opportunity, or did you assault or commit an assault and battery on the person of Dana Stott in this case?
Yeah, it started off in an argument and then it got out of hand and we got out of control. So yes, sir.
Okay. And that would mean that you offensively touched Mr. Stott.
Yes, sir. We both did.
All right. All right. And you'd agree with me that the time that you offensively touched or put put Dana Stott in fear, they were not defending themselves. You were committing the crime of assault and battery.
No, sir.
So you don't agree with that?
No, sir.
Aaron, I apologize. I think you phrased the question. You didn't think they were defending themselves.
Right. So I might have done a double negative there.
I think so.
So, Mr. Karn, just to be clear, you were not defending yourself when you committed the crime of assault and battery. Isn't that
No,
true?
sir.
You were not acting. You were not defending yourself, sir.
That's correct. That's correct. I think I did it again. All right. So we understand. You did assault Mr. Stott.
Yes, sir.
All right. Thank you. I find the factual basis in this to be understanding, voluntary, and accurate after several questions. Any questions on the factual basis from the people?
Oh, yeah, no, thank you.
So that's anything from the defense.
No, Your Honor.
Okay, there's no restitution in the matter. I'm going to refer to the matter to probation. Okay. So within 48 hours of getting out of jail, you're to refer to probation in this matter. Do you understand that? You still have your pretrial conditions involved, no contact orders at this time. Do you understand that, Mr. Carter?
Yes, sir.
All right. And then if you're able to make bond, you should report to probation within 48 hours. Do you understand that?
Yes, sir. What's my bond?
Right now, your bond on this file is remanded on the PA 53. Your bond on this file is, well, you're remanded on both, I would think, because you have a no contact order as to both. The initial bond in this matter was set at 2,010%.
So 200.
Correct.
Okay,
So, and I'm gonna leave that bond in place, the underlying bond of 2,010% in this file. Anything else,
Okay.
and we'll address the PA 53. Anything else on this file from the prosecution?
Sentencing date, Your Honor.
Correct?
Sentencing date, please.
Oh, thank you.
Yeah.
Sentencing date in this matter, August 22nd
August 22nd.
at 9 a.m.
Back door, please.
So is that all right? August 22nd at 9 a.m.?
Well, Your Honor, it's another situation where I've already taken personal leave for that
Right.
day, so I will not be in county.
Right.
That hearing I could likely have if the other matters are more of an issue.
Yeah, we'll cover it. It'll get covered. So,
Okay.
all right, so that's all on the pretrial matter in this case. Now we'll go to the PA 53 that's also been scheduled. And my understanding of the victims are here in this PA 53. All right. So I'm going, may I inquire of the victims?
Yes, I have no objection to that, Your Honor.
All right.
It would really just be Mr. Scott.
Mr. Stott, okay. Mr. Stott, can you come up here? And I want to make sure that everybody's on the same page here. So I'm calling the PA 53, which is a violation of the no contact order 2103153. Previous parties have introduced themselves for the record, Ms. Housefield and Ms. Sutter. Mr. Stott, you are the victim in the no contact order, is that correct? All right. And this is just for my own, so I feel comfortable doing this, all right? This is a family matter, no contact order, okay? And there seems to be, do we all have an understanding now that although the defendant may come to the residence, he may also be violating portions of the no contact order, which gives rise to the PA 53. And you've been talked to about that by both the prosecutor and defense counsel in this matter. All right. Under the courts looking at this, and it's going to be a part of the probation, there's going to be a no contact order. All right. That's to make sure that the community's safe and the victim's safe in the case. And what I'm going to tell Mr. Karn, I'll tell the same to you, is that the onus is on him to stay away. All right. As long as he's in violation, then he's violated, and then we end up in court again. And so the onus is on you to make sure, for his own good, not to get him there, right? So that he's not in violation, that there's no confusion, all right? Because ambiguity is the danger here, all right? And the danger falls on him because he's the one who's going to be violated, all right? Do you have an understanding of that? Sure. All right. I just want to make sure so there's no mistake or ambiguity here for Mr. Karn's sake and for the sake of your family. You understand that? Sure. All right. Ms. Housefield.
If I may just clarify for the record, it was not Mr. Stott that invited him home.
Right.
It was his mother.
Right.
And I think it should also be made clear that there is no contact with Ms. Feldposh. So if Ms. Feldposh wishes contact, she may do that as long as it is not with Mr. Stott, but he may not come to the residence while Mr. Stott is present at the residence.
Correct. Yeah. If he's within a certain amount of feet of you, that puts him in violation. So let's not do that. Let's do everything to avoid that. All right. All right. Mr. Karn, do you understand that?
Yeah, I have to be 1,500 feet within Dana Stott.
Okay, and that, if you keep clear on that, we're good to go, all right?
Yes, sir.
All right. Based on the information provided by both the people and the defense in this case, I'm going to dismiss this PA 53 violation. There'll be no further contact in regards to the victim and the defendant. I feel good that everybody understands where this is set. And so I'm going to dismiss the PA 53.
Thank you, Your Honor.
Anything else for this file, Ms. Housefield?
No, Your Honor, thank you.
Thank you, Mr. Stott. Ms. Sutter?
I have nothing further, Your Honor.
All right. That's all on the record in this docket 2103153. Mr. Karn, we will see you at sentencing on August 22nd at 9 a.m. Okay?
Okay,
All right. That's all for the record in both of these files. Thank you. Thank you for your appearance today.
see you, Dana. So I'm all set.
Set, sir. You're all set.
Back door. Back door. Hey, Flores? Yeah. Is he done with the polycount? Yeah. All right. Do you have anybody else, sir?
The jail, not at the jail. We're good. Thank you so much.
Thank you.
No. Miss Khalil, you're here on arraignments?
Yes, she has,
Yes,
she has one of them.
Crazy.
You're live in the court right now. They can hear you, boss. I know it is, but I'm hoping we can get you guys up. I think we're all ready.
Hang on 1 second. One of us is not. All right, so we'll do Jonathan Barnes for arraignment. So the first file. All right, we're on the record in docket 21-03517. Sir, you are Jonathan T. Barnes.
Yes.
Okay. And counsel, your appearance for the record?
Wayne Silverthorne from the Office of Public Defender on behalf of Jonathan Troy Barnes, who I see is appearing on screen from the Lansing City Jail. My appearance today is limited to this arraignment.
All right, and sir, this is the date for arraignment on this file. We have two other files, but it's on this file concerning charges and some of the rights that are associated with those charges. So I'm going to indicate what allegations have been made pursuant to the complaint against you. All right, sir?
Okay.
All right, these are allegations at this point. So on or about the offense location of 4019 South King, Lansing, Michigan. On June 8, 2021, the complaint alleges that you, Jonathan Troy Barnes, did trespass by refusing to leave upon the premises of another 4019 South King, Lansing, Michigan, contrary to the provisions of the Code of Lansing, that being 660.02. The maximum penalty is 90 days and or $500 pursuant to 257-6251B. Penalty is 93 days and or, no, that's 90 days and or $500 under the city code. Do you understand the nature of the charges against you, sir?
Yes.
All right. You have certain rights that I will cover concerning these charges. You have the right to have a trial in this case. You have the right to have witnesses called in your defense. You have the right to cross-examine all witnesses. You have the right to testify to remain silent without an inference of any of that being used against you in a court of law. You have the right to the presumption of innocence, and you have the right that requires your guilt that guilt be proven beyond a reasonable doubt. Do you understand your rights if you go to trial in this matter?
Yes, Your Honor.
And you are represented by Attorney Dwayne Silverthorne for brief purposes of this arraignment. Do you plan to seek the assistance of counsel for future hearings in this file?
Yes, Your Honor.
Okay. Do you plan to make application to the public defender's office?
Yes, Your Honor.
I'm going to indicate that you do plan to make application for public defender. Sir, your next pretrial date in this matter is July 25th at 9 a.m.
Okay.
Do you have a address for the court file?
Yes, it's 812 East Jolly Road. 812 East Jolly Road, Lansing, Michigan, 489. Yes, Jolly Road, Jolly.
Okay. Lansing, Michigan.
Yes,
And what's the zip code?
48910.
All right. And do you have a phone for the court's file?
No, sir. No, Your Honor, I mean.
All right. Sir, are you on probation or parole at this time?
No, Your Honor.
Are you employed?
Yes, Your Honor.
And where are you employed, sir?
Oh, Your Honor, I do maintenance, Your Honor.
All right. Are you self-employed or do you work for someone? Self-employed? Okay.
Independent contractor.
All right. Okay, I will automatically enter a not guilty plea at this arraignment. Mr. Silverthorne, would you like to address bond?
Just briefly, noting that this is a 90-day victory. He says he doesn't have a violent criminal record. He indicated he was truthful, that he had some failure to appear as a record, but generally he did appear. Given all of this, I would think that this would merit probably a PR bond of some sort.
Please look, I'm gonna peek at. So they're all the same FTA. And I bet you they're all the same date. No. Sir, I'm gonna if you're able to make bond on this matter, I'm gonna set it at a PR bond on this file. PR $500.
Okay.
So the bond is set at PR $500. I have two more that I have to arraign you on. It's the same fail to appear on the same date, but that's all on the record in this file of 21-03517. Stay right there, sir, and we'll start on the second file.
All right.
Which is docket 21-03522. And sir, once again, you are Jonathan T. Banks?
No, I'm not.
Barnes. Jonathan Barnes.
Yes, Barnes.
Thank you, Nathaniel. And Mr. Silverthorne?
Dwayne Silverthorne on behalf of Jonathan Troy Barnes, who is appearing on screen. Appearance again limited to this arraignment.
Right, Mr. Barnes, I'm going to read the arraignment, which was the fail to appear arraignment for the following that is in on or about June 11, 2021 at the offense location of 1100 Ramada Drive, that you did knowingly furnish a Lansing police officer with false information, an incorrect name and date of birth, at or near the vicinity of 1100 Ramada Drive, City of Lansing, Ingham County, during the officer's investigation, a violation of state or local or ordinance contrary to the code, Lansing Code, that's 602.03. It's a 90-day misdemeanor and or $500. In count 2 of the same allegation complaint misdemeanor, you did hinder, oppose, obstruct, or resist the Lansing police officer in the performance of his or her duties at 1100 Ramada Drive, Lansing, Michigan, contrary to the provisions of the Code of Lansing, being 602.02 maximum penalty of 90 days and or $500. Do you understand the nature of that complaint against you, sir?
Yes, Your Honor.
All right. You have certain rights in this file. You have the right to have a trial. You have the right to have witnesses called in your defense. You have the right to cross-examine all witnesses. You have the right to testify to remain silent without an inference being drawn. You have the presumption of innocence, and you have the requirement that your guilt be proven beyond a reasonable doubt. Do you understand those rights, sir?
Yes, Your Honor.
And you are represented by Dwayne Silverthorne from the Public Defender's Office in regards to this file. Do you plan to seek additional representation from the Public Defender's Office in this file, sir?
Additional, like an extra one, or just him himself?
It would be similar to the representation that you said in the first file. So you'd be making application to the office in order for them to represent you in future hearings.
I mean, I want the same attorney the same public defender that's assisting me now to assist me in all of these matters, Your Honor.
Right. You would have the same attorney appointed to all your files.
Okay, so additional doesn't mean like an extra one, right?
It just means it goes to the file more than it goes to the attorney himself or herself.
Okay.
Okay.
All right.
So I'm going to indicate for the file that you're going to seek assistance from the Public Defender's Office. I can transfer your phone number and address for the file, your probation and parole, the fact that you are employed, self-employed. I'll enter a not guilty plea at this arraignment. The pretrial on this matter is set for July 25th, 2022 at 9 a.m. You should receive some documentation in regards to that. That's on this file. I'm going to enter a not guilty plea on your behalf at this arraignment. Mr. Silverthorne, would you like to be heard on bond?
Yes, I'll actually rest up my earlier comments on his previous file and ask for a PR bond.
All right. I'm going to set bond in this matter. This is also furnishing false info and resisting, and it's the information count of hindrance and oppose at PR $500. So bond is set at PR $500, and then we're going to do one last file for you. So I'm on the record in dockets. $22,00172. And sir, for the record, you are Jonathan Barnes once again?
Yes, Your Honor.
Okay, and counsel your appearance for the record.
Plain Silverthorne, Office of Public Defender, by hand of Jonathan Troy Barnes, who's appearing on screen. My appearance is limited to this arraignment, and I would indicate that on all of his cases, he's requesting a part-appointed attorney.
Okay, perfect. All cases. So this time that I'm going to read you the allegations of the charge against you and some rights you have in regards to those charges. The allegation is in a misdemeanor complaint that on July 12th, 2021, at the offense location of 6200 South Pennsylvania Avenue, City of Lansing, Union County, the defendant did in count one, while Meyer was open to the public, steal property of the store that was offered for sale at a price of less than $200. Contrary to the laws of the state of Michigan, that's 750.356D4. That's a misdemeanor, 93 days and or $500, or 3 times the value and price of property stolen. Do you understand the nature of that charge against you, sir?
Yes, Your Honor.
And you have certain rights that coincide with the allegation. You have the right to trial. You have the right to witnesses to have witnesses called in your defense. You have the right to cross-examine all witnesses. You have the right to testify, to remain silent without an inference being drawn from your silence. You have the right to presumption of innocence. You have the requirement that you're guilty proven beyond a reasonable doubt. Do you understand those rights, sir?
Yes, Your Honor.
It's my understanding that you're making application to the public defender's office, that the current pretrial for this matter is set for July 26th, 2022 at 1:30. I believe that would be in front of Judge Simmons. Do you understand that date and time, sir?
Can you repeat the date and time?
July 26th, 2022 at 1:30 p.m.
Oh, yes, Your Honor.
All right. I can transfer any phone number and address for this file, the fact that you are not on probation or parole, the fact that you are self-employed. I will enter a not guilty plea for arraignment. Mr. Silverthorne, would you like to address bond?
I'll rest on my earlier comments, Your Honor. Thank you.
In regards to this, I will indicate that there is to be no contact with Meyer during this proceeding. Since they are considered a victim. So I'm going to have no contact with Meyer in regards to this retail fraud. No out-of-state travel. It's a misdemeanor. So no contact and no out-of-state travel at this time.
All right.
I'll add no use of alcohol or drugs without prescription. I will set bond at PR $500. Anything else for the record in docket 220172, Mr. Silverthorne?
This would actually apply to all of them. Will his appearances for his trial be by Zoom or in person? I'm noting he doesn't have a phone.
Yeah, I'm thinking that it should probably be in person. Yeah. So in regards to all of these matters, you should appear in person in order to meet your the requirements for your appearance. Do you understand that, Mr. Barnes?
Yes, Your Honor.
All right, thank you. So that's all on the 3 files with Mr. Barnes. You have your pre-trial notices, and you should respond in person to those pre-trials. Do you understand that?
Yes, Your Honor.
All right, that's all on that file.
Before we go to the next file, his first 2 cases, I thought maybe all of us. Because it was Simmons.
I'm guessing at that because that's what it was on her.
You can go.
Mr. Barnes, you're all set, and we'll do Mr. Jimmy L. Clark next. Has he ever been on this?
How you doing, sir?
All right. So we're going to go on the record in docket 1902735. That is a People versus Jimmy L. Clark. Will the parties please? I'm sorry. You are Jimmy L. Clark, sir?
Yes, sir.
All right. And for the record of council's appearance?
Wayne Sullivan, now on behalf of Jimmy Lee Clark II. I see Mr. Clark is appearing on the screen, and he has made application for an attorney. My appearance today is limited to this arraignment.
And sir, it appears that this arraignment is for a fail to appear for pretrial on June 14th, 2022 at 9:30. It was requested by Nicholas Bigelow on June 14th, 2022, and it was signed by Judge Christian Simmons on June 14th. Do you understand the nature of the charges against you, sir?
Yes, sir.
All right. And you understand that in regards to this fail to appear, the bench warrant was issued, and that is the reason for the bench warrant being issued for fail to appear on this date. You understand that?
Yes, sir.
I want to make sure your updated information is correct here. Do you still live on Park West, apartment K9?
Yes, sir.
And is your phone number still valid at 248-306-7401?
Yes, I also got a secondary number because people
Is
can't
that
always.
517? Is that 517-702-8561?
Yes, sir.
All right, perfect. Are you just to update the information, are you currently on probation or parole?
No.
All right. I'm going to enter a not guilty plea on your behalf at this arraignment on the fail to appear. Counsel, would you like to address bond?
He indicates that he hasn't got a violent criminal record. He has admitted to me that he had some failure to appear. Some of them are related back during the time of COVID. One time because he had a death in the family, and he indicated another time, such as he recently took himself voluntarily to Eaton County and addressed the matter there. He's got ties to the community. He's formerly worked at Myers Warehouse. He now works at Dimitri's Restaurant as a dishwasher and also as a cook. He was raised in Lansing, and he has two brothers that are still in this area, and he's the father of 3 children. I would leave to the court's discretion if the court was to inquire as to the reason for the failure, but I would think that you should have some consideration at least for a PR bond.
I'm gonna indicate for the record that the basis for I'm setting bond in this matter. It's a retail fraud third, only because of your numerous fail to appear. I've got you failed to appear on February 11th. I have a bench warrant issued for you on May 24th. So 2 previous failed to appears. It appears that working is good. I'm glad you're working and employed. I'm going to the bond was initially set at 200 cash surety. I'm going to set it at $100 cash bond. So it's $100 cash bond at this point in time based on the fail to appears. Anything else for the record in 1902735, Mr. Silverthorne?
Is there going to be another date set on this matter?
I don't have a date set for this. Is there anything in the? I do. I have a pretrial set on July 26th, 2022 at 9:30.
Which judge will that be with?
That's with Judge Simmons. Yeah. And then I have a felony file. So go on the record in docket 22011822. People of the state of Michigan versus Jimmy Clark Jr. You are Jimmy Clark again, sir?
Yes, sir.
All right, and this is the time set for arraignment on a felony matter. Mr. Silverthorne, your appearance?
Wayne Silverthorne from the Office of Public Defender on behalf of Jimmy Lee Clark II, who is appearing on screen. He has made application court appointed. My appearance today is limited to this arraignment.
Thank you. And this is the time set for the arraignment on the new felony file. I'm going to read the allegation against you and then read some of your rights in regards to this felony file. So, Mr. Clark, the allegation is that on or about July 11th, 2022, at South Cedar Mount Hope, City of Lansing, Ingham County, in the state of Michigan, the defendant, Jimmy Lee Clark, did in count 1, carry a dangerous weapon, to wit, a pistol, whether concealed or otherwise, in a vehicle operated or occupied by said defendant, to wit, a white Buick, contrary to the law of the state of Michigan, that being 750.227, being felony 5 years and or $2,500, and a mandatory forfeiture of a weapon or device. The court may order DNA identification sampling in regards to this case that was not, if it was not taken at arrest. Do you understand of the nature of the 5-year and or $2,500 felony that you're being arraigned on, sir?
Yes, sir.
All right. You have certain rights in regards to that file. One is that you have the right to have a trial of any kind. You have the right to be tried by a jury, to be presumed innocent until proven guilty, to have the prosecutor prove beyond a reasonable doubt that you are guilty, to have witnesses called in your defense to appear at trial, to question the witnesses that are being brought against you. You have the right to have the court order any witnesses that may appear for you at trial. You have the right to remain silent, not to have that silence used against you in any way, and to testify at the trial if you want to testify. This is a felony case, so you'd also have a right to a preliminary examination within 21 days. At that time, that would be a probable cause hearing to determine there's probable cause to believe that you committed this crime. The crime was committed, and you, as being the person of identity that created the crime. Do you understand your rights in this case, sir?
Yes, sir.
Yeah, you've indicated that Dwayne Silverthorne has indicated that he's from the public defender's office and he represents you for purposes of this arraignment. Do you plan to seek additional? Well, he's already applied, I think, right?
Yes, John.
Okay. So you do plan to seek additional representation from the public defender's office?
Yes.
Okay. I believe I can transfer your current dates for this file. You have a probable cause conference on July 21st, 2022 at 1:30. And you have a preliminary examination scheduled for July 29th, 2022 at 8:30. Those will all be in front of Judge Simmons.
Okay.
I believe I can transfer from the other file your address, your phone number, the fact that you were not on probation or parole, and that you are currently employed at Dimitri's. Is that correct, sir?
Yes, sir.
All right. I'm going to automatically enter a not guilty plea in your on your file. Counsel, would you like to address bond?
Briefly, I would stand on my earlier remarks and also indicate that although carrying dangerous weapon is a felony, it is not per se a dangerous offense. And again, that he's working and he has ties to the area.
Thank you. Sir, if you're able to make a bond that is set, the following conditions will be set in regards to this. There's no use of alcohol or drugs without a prescription, no out-of-state travel, no possession of a firearm, and to report within 48 hours to pretrial services upon release.
I have a quick question.
Sure.
So I have to pay $100 to get out of this downtown jail?
I haven't said, for right on your other file, yes, I have not said bond on this file.
All right, I got another question. Because I gotta go to Ingham. Is there any way that you can PR bond me out of here and I go to Ingham and handle my business, please?
Not on the other file because bond has been set and I've yet to address bond in this file.
Okay.
Based on, so if you're able to make bond, those are the conditions of bond, a pretrial set. This is a felony. It appears that there is a prior, correct. There's a prior juvenile adjudication out of 2012 that I'm going to disregard. I have 2 prior R&Os, a prior, I don't know what happened on the methamphetamine case, and then a malicious destruction of business case as a part of your CCH. In regards to this, to your criminal history, sir. In regards to this felony with the $2,500 max, I'm going to set bond at 5,010%.
May I have permission to speak, Your Honor?
Hold on. So bond is set at $5,000, 10%. And your counsel's already argued on behalf of your bond, sir. So if you have counsel, I don't know if you want to state anything for the record at this point.
Yes, I have a hold in Ingham. How I'm supposed to go to my court date in Ingham if I don't get PR bond out of here. I currently don't have the funds, the bond out at the moment. I won't have that funds to another 2 weeks. And I got appointments and then I got a family member that died in my family. I'm trying to help pay for the funeral and attend the funeral. And the only way to do that is if I get PR bond out of here and go see about what I got going on in Ingham.
Sir, this is your attorney, when you say Ingham, do you mean the 55th District Court out in Mason?
Yes, yes, in Mason. Yes. All I'm asking is to get. I realize my charges here. All I'm asking is to get PR bonded on the charges here, so I can handle the charge in Ingham. Because, like I said, I can't afford to pay right now. I don't get paid to 2 weeks.
I can probably, I know where you're going. I can answer your question. The county, the city jail doesn't continue to hold you. If you don't make bond on this case immediately, you'll be transported out to Ingham County. When they're aware that you have a hearing, that's in the same building as the 50th District Court, you'll be able to address the matter at 50th District Court. Even if it's set for tomorrow, you'll be able to address it.
So I'm gonna be into this. I'm gonna stay into the downtown jail overnight.
Actually,
you'll be transported to Ingham County Jail.
Yes, probably fairly quickly.
All right.
Okay, that's all right. That's what I want. So,
all right.
So even if I go to Ingham and I take care of that, I still have to bond out with you guys to get out of Ingham.
Correct. You have two files to bond out on, and this bond's been set at 5,010%.
Sir, basically, it sounds like you have 3 files. You have the 2 here that originate in the 54A District Court, which covers the city of Lansing. And apparently you have a file of a pending case out at the 55th District Court. You'll have a bond. Every case has to have a bond set. So they'll have to set a bond out there. And then when you post those bonds, then you'd be out.
So I'm gonna have a bond from y'all and Ingham, basically.
That is,
yeah, for every file you'll have a bond on.
All right, how much do I owe to you guys total? 600?
But let me go. I don't, so you owe 600, 500 on one file, 100 on the other, and then you still have a collections matter we should deal with. So let me make sure that'll be a much faster. You have a collections file, and I'll state that for the record, 1601816. I have you having an outstanding balance on this file of $495.71. And sir, what I'm going to do on this file is I'm just going to refer it to collections. So there'll be no bond set. There was a bond set. I'm just going to refer it to collections. You will have to, once you're out, you will have to contact the City of Lansing Criminal Division Collections to set up a payment plan. A bench warrant was issued for you for that $495 debt. And right now I'm just referring that to collections because that's the least of your problems right now. The most of your problems are the two files that you have in front of the City of Lansing, which are 5,010% on one file and then $100 cash on the other. Do you understand that, sir?
So I gotta pay 600 to get out?
I guess that's the bottom line, yes. And then once you're out, if you're able to get out, you should contact collections so that you can start making a payment on the outstanding $495 debt.
Okay, what if I can't get out though?
Well, when you're able to get out, that's when you're going to be referred to collections. On the other files, we'll see how those take care of themselves. So that's all on the record in 1601816. Your next date, you should have a note indicating when your next date for your other files are. So that's all for the record on Mr. Clark's files. We have a Creon Kirk.
Yes, Your Honor.
Get a little closer. Thank you, sir.
Yeah.
Failed to appear. All right, so I'm going to call to the record docket 19-03107. And sir, you are Creon Kirk?
Yes, Your Honor.
All right. Counsel, your appearance for the record.
Wayne Silverman on behalf of Creon Ray Kirk. I'm from the Office of Public Defender. Mr. Kirk has made application with court appointed attorney. My appearance today will be limited to this arraignment.
All right. Sir, I'm going to tell you the nature of the allegation for the warrant against you, and then some rights you have in regards to that warrant. But a warrant was signed by Nicholas Bigelow on June 27th, 2019. It was signed by Judge Christian Simmons on May 11th, 2021. The bench warrant was issued for the defendant failed to appear for a violation of probation hearing and probation on May 10th, 2021 at 1:30. That is the nature of the violation against you and why the bench warrant was issued. Do you understand that charge, sir?
Yes, Your Honor.
All right. And you have certain rights concerning that charge, the right to have witnesses brought and to contest those, the probation violation. You understand that, sir?
Yes, Your Honor.
You are you still at the same? I have a number of 517-763-3020. Is that still a good number for you?
No, Your Honor. This is I have
what is an up? Do you have an updated number?
517-214-2177.
And do you have an updated address, sir?
Yes, Your Honor. 1029 Cooper Avenue, Lansing, Michigan, 48910.
Are you on probation or parole?
No, Your Honor.
Are you still employed at A and B Roofing.
No, I'm at Hope Plastics Industrial.
Okay, I'm gonna enter a not guilty plea for purposes of probation violation. Mr. Silverthorne, would you like to address bond?
He did reveal that 15 or 20 years ago, he did have an assault GBH in B&E. And he does have a hold in Eaton County, but he hasn't had much of a record since then. And I know he was quite young at that time. He's only 41 now. He indicated that he did appear, although he said that he did have some non-appearances during the COVID era. He's lived in the Lansing area for 20 years. He has 6 children here. He is set to go to work later today if he can get out. He pays child support, as I said, on 6 of the kids. And this is pursuant to an income withholding order. Given his responsibilities, I would think that PR bond should be considered.
I'll consider the PR bond. This essentially comes from a domestic and assault GBH. Originally, defendant failed to appear and was bench warranted on May 1st. The bond was set at 1,000 cash or surety at that time, 1,000 cash or surety in regards to that. And then there was a fail to appear. And bond had been reduced at least once because it started out as 25,000 cash or surety. And then the bond was issued a 1,000 cash or surety on this case. So on this file, the bond conditions are to remain, to stay intact in regards to all the bond conditions and that were essentially addressed by probation. And I'm going to set bond in this matter at 300 cash. So that's all on the record.
Does he have any hearings that are coming up?
I don't have.
This is a failure to appear.
Yeah.
You should have to appear at something.
Let's see if I can. I do. 7:20. So thank you, Mr. Silverthorne. I have a hearing on this matter set for it's a violation of probation of bond in front of Judge Simmons on July 26th at 1:30.
Thank you.
So that's all on the record in docket 19-03107. We have Miss Jamie Lugo is next. Is that
empty?
And Ms. Khalil, you're here for the Public Defender's Office?
Correct, Judge Flores.
All right.
Closer, Taylor. A little closer? Yes, sir. So you can see a little better. Okay, is that good like that? Hey.
So I'm going to call the file 22-01048, People of the State of Michigan versus Jamie Lugo. You are Jamie Lugo, sir?
Yes, Your Honor.
Okay, and you can hear me all right, Mr. Lugo?
Yes, sir.
And ma'am, your appearance for the record?
Good afternoon, Your Honor. Yara Khalil from the Office of the Public Defender, appearing under the supervision of Attorney Dwayne Silverthorne pursuant to MCR 8.120, appearing on behalf of Mr. Lugo for his arraignment today only.
All right, Mr. Lugo, this is the arraignment. I'm gonna indicate the nature of the charges against you, and I'm gonna indicate some of your rights in regard to those charges. This is a misdemeanor complaint allegation that on or about January 22nd, 22 at the offense location of 316 East Michigan Avenue, City of Lansing, Ingham County. Yourself, Jamie Raul Lugo Jr., did in count one make an assault without being armed with a weapon upon Donald Williams, and did inflict a serious or aggravated injury upon said person, but without intending to commit the crime of murder or to inflict great bodily harm less than the crime of murder, contrary to the law of the state of Michigan, that being under pursuant to MCL 750.81A1, that being a 1-year misdemeanor and or $1,000 in fines. Do you understand the nature of those charges against you, sir?
Yes, sir.
In regards to this misdemeanor charge, you have certain rights. You have the right to trial of any kind. You have the right to have a trial. You have the right to have witnesses called in your defense. You have the right to cross-examine all witnesses. You have the right to testify or remain silent without an inference being drawn from your silence. You have the right to the presumption of innocence, and you have the right to have the people prove beyond a reasonable doubt of every element of the crime. Do you understand your rights in this case, sir?
Yes, Your Honor.
And you are represented by Ms. Khalil from the Public Defender's Office. Do you, only for arraignment purposes today, do you intend to seek the Public Defender's Office to represent you in future hearings?
Yes, Your Honor.
Okay. So yes, so I'm going to indicate for the file, you intend to make application to the Public Defender's Office?
Yes, Your Honor.
I have a pretrial date scheduled in this matter for July 25th, 2022 at 9:30. That's in front of Judge Buchanan. Sir, do you have a current address for the file?
Yes, my current address is 6003 Cypress, CYPRESS Street, Hazlet, Michigan, 48840.
And do you have a current phone number?
Yes, sir. It's area code
And what is that, sir?
517
Okay.
285 5872.
All right. Are you on probation or parole, sir?
No, sir.
Are you employed at this time?
Yes, sir.
Where are you employed?
I work for the IBEW Local 665.
Say it again, I'm sorry.
IBEW Local 665.
Okay. I'm going to enter a not guilty for arraignment purposes on your behalf today. Ms. Khalil, would you like to be heard on bond?
Yes, Your Honor. Mr. Lugo is a lifetime resident of Michigan. He also has his parents and siblings in the area. He has been holding a steady job at IBW as an electrician for the past 3 years. To his knowledge, he doesn't remember ever failing to appear in court. And it looks like he doesn't have any relation to the complaining witness in the allegation. So there would be no problem maintaining no contact during the period of the case. And for those reasons, we would ask for a PR bond if the court finds it appropriate.
Sir, if you're able to make a bond on this misdemeanor case, I'm going to have the following conditions of bond. That you are not to use alcohol or drugs, that you're not to have any assaultive behavior, that no out-of-state travel, no contact with the victim in this case, and the victim in this case being Donald Williams. No possession of a firearm. This is a 1-year misdemeanor, which is the highest misdemeanor that you can have. I also have, Mr. Lugo, although you've been gainfully employed recently, I do have an extensive or somewhat extensive CCH
Yes, sir.
in regards to prior misdemeanor assaultive conduct, prior felony assaultive conduct, 1 other weapons charges in which you pled guilty to, and then several smaller misdemeanors. So for purposes of safety to the community, I'm going to set bond at 5,000, 10%. If you're able, so if you're able to make bond, there's a continued no contact order with Mr. Williams. I will put as a part of that bond also a GPS requirement that tether is ordered and victim notification in regards to the ag assault.
Will there be a curfew or something enforced, or is this just to make sure I'm not going anywhere near the victim?
The GPS, if you're able to make bond, GPS will be tethered to you. And so they'll know if you're within 1,500 feet. So that they'll set the conditions of where you can go in regards to the GPS device. If you do violate, the victim will be notified immediately. Do you understand that?
Yes, sir.
All right. Anything else for the record, Ms. Khalil, on 22-01048?
Nothing further, Your Honor.
All right. On your next date, sir, is July 25th, 2022 at 9:30. All right?
Thank you, Your Honor.
Thank you. And then I'm going to do Mr. Schuster, and then we'll do the last one. Yeah. So you'd have to bring up Mr. Pulley, right? So, sir, are you John Schuster?
Yes, sir.
All right. Just making sure. So we're on the record in docket 22-01824. People, the state of Michigan versus John Schuster III. And you are John Schuster, sir?
I'm the second, sir.
What's that?
I'm John Schuster, the second.
Oh, John Schuster the second. All right. I was the third, so John Schuster the second. Counsel, your appearance for the record.
Dwayne Silverton, on behalf of John Scott Schuster II, who's appearing on screen. I'm from the Office of Public Defender. He has requested a court-appointed attorney, and my appearance today is limited for the purposes of the arraignment.
Thank you. Sir, this is the time set for arraignment in this matter. I'm going to read the allegations against you and then read you some rights in regard to those allegations. Do you understand that?
Yes, sir.
All right. The felony complaint filed indicates that on or about July 10th, 2022 at Kalamazoo, Pennsylvania, city of Lansing, Ingham County, the defendant, yourself, John Scott Schuster II, did in count 1, carry a dangerous weapon, to wit, a pistol, whether concealed or otherwise, in a vehicle operated or occupied by said defendant, yourself, to wit, a 2012 Nissan Altima. Contrary to the law of the state of Michigan, that being statute 750.227, that is a felony, 5 years in prison and or $2,500. Do you understand the nature of the charges against you?
Yes, sir.
You have certain rights in this felony matter. You have the right to a trial. You also have the right to be presumed innocent until proven guilty. You have the right to have the prosecutor prove beyond a reasonable doubt that you are guilty. You can call witnesses to appear for trial as a part of your defense. You have the right to question any witnesses brought against you. You have the right to have witnesses brought in your defense. You have the right to remain silent. You have the right to not have that silence used against you in a court of law. and you have the right to testify on your own behalf. Do you understand the rights at trial concerning this case, sir?
Yes, sir.
You also, this is a preliminary examination case. It's a felony. So you have the right to a probable cause conference and exam. You have a right to an exam within 21 days in which the people would have to prove that there's probable cause that the crime was committed and probable cause that you committed that crime. The probable cause conference has been set for July 21st, 2022 at 8:30 in front of myself, Judge Flores. An examination date is set for July 28th, 2022 at 8:30. You're represented by Mr. Silverthorne here at arraignment. Do you plan to seek counsel with the Public Defender's Office for future hearings, or do you plan to retain counsel?
The Public Defender's Office, sir.
Okay. So you'll be making application to the Public Defender's Office for future hearings. Is that correct, sir?
Yes, sir.
Do you have a current address for the file?
Yes, sir. It's 4601 Devon Drive, Jackson, Michigan, 09201.
And what's the name of that street again? 1601.
4601 Devon, DEVON Drive.
All right. Do you have a phone number, sir, that you can be reached at?
Yes, sir. It's 517-348-9429.
Are you on probation or parole?
No, sir.
Are you employed at this time?
Yes, sir.
Where are you employed, sir?
I work at Alliance Interiors as a forklift driver.
For this felony file, the court will enter a not guilty plea at your arraignment. Counsel, would you like to address bond?
Yes, briefly. He doesn't have a violent criminal record. He has some minor drug offenses that leads to marijuana in his past. He also indicates that he's always appeared in court. As he indicated, he works. In fact, he's scheduled at 2 o'clock today. He's lived in this area for 10 years. His family is very close by in the Jackson area, and his daughter actually lives in this area, so he has ties to the community. With carrying a concealed weapon is dangerous, but it's not classified as a violent offense in terms of the community. So I ask the court to take that into consideration.
If you are able to make bond in this matter, the following bond conditions will apply. No use of alcohol or drugs without prescription. No assaultive behavior. No out-of-state travel. No possession of a firearm in this matter. And you're to report to pretrial services within 48 hours of release. There's a limited history here in regards to misdemeanor conduct. There's one crime that ended up in Nollycross. I'm going to set bond in this matter. At $2,500, 10%. Which is the 10% of the maximum fine. Of course, this is just an allegation at this point. It is a firearm offense, though. So $2,500, 10% with a small criminal history. Anything else for the record, Mr. Silverthorne, 2201-824?
No, Your Honor.
All right, Mr. Schuster, your next date, as indicated, are July 21st at 8:30 and July 28th at 8:30.
Okay, thank you, sir.
Thank you. You're all set.
Your Honor, we are on our way up with Mr. Pulley right now, if that works for you, sir.
All right, and we'll see, we'll get the translator all set up too.
Fantastic. We'll see you in like 4 or 5 minutes.
All right,